Hey everybody, how we doing? You all may or may not have missed the first 15 minutes of a really great stream. It was a really great 15 minutes. I'm glad I'm kind of sad you weren't here to enjoy it with me. Uh, yeah. Mm. It was a Hey, it was a good 15 minutes. Well, I'll just consider that a practice run. I don't know what happened. Well, I kind of do, but I don't, because everything was set to go. We were good to go. Everything was in its proper place. The world was rotating on its axis. The song of the spheres of the universe. Everything was in play. I got here at like 5 minutes before showtime and found out that I had a mandatory update with a mandatory reboot on my system waiting for me. So I did that, got everything set up again. About 2 minutes after 10 a.m. my time. Is 10:17 now. I clicked the go live, and for some reason it didn't do that. So I should have checked, but I just assumed that if I click go live, it goes live. It didn't. It clearly didn't. So there we go. But anyway, wow. Kind of feels weird to do this whole thing all over again. We'll just kind of keep it simple. Thank you to everybody that joined in with F Friday yesterday. We had a great time. Chandler Remington was supposed to be joining today, but she's feeling a little under the weather. Has a bit of a headache. I don't know if you're watching, Chandler, but if you are, get better soon. So we're going to go solo with this. And where we left off here in the YNW Melly trial was the afternoon of day 4, which was last Thursday. The court only goes Monday to Friday. Monday to Thursday, and then Friday the judge handles other cases. What we've got here today is we're starting out with the testimony of the mother of the female friend of the defendant. And she's, now, by the way, no spoilers in chat, please. For those of us that haven't watched this, that know nothing about what's happening, we want to have the joy, the anger, the surprise, the boredom, however it happens, occurring naturally. So if we can all avoid it, please do us all a favor and don't post any spoilers about anything that happens ahead of where we actually are in the trial. Just a small little request for that, so that we can keep it natural, keep my reactions natural, keep my comments natural. Let's see. Don't have the poll up yet because I actually had more time than I thought because I wasn't live, but I didn't think I had any time. Wouldn't it have been fun if I would have just started the video and set up the poll? Then you really would have been wondering. But all right, what we've got with this witness, she's having problems recalling things, apparently. And the prosecution is asking questions like, well, what did you do then, or what did you see, or what did you? And her answers are, I don't remember, I don't recall. There's a lot of those answers, and she's a smart woman. This witness is smart. She's clear. She's precise with her answers, and the prosecution thinks she's being cagey. She's answering the questions apparently honestly. Because if someone asks you, what did you have for breakfast yesterday? And you don't remember what you had for breakfast yesterday, you say, I don't remember what I had for breakfast. Don't say, I think I had this and I may have had that, but then we went over and had some coffee. And then, while we were doing that, I was thinking, boy, I wish I would have had this for breakfast. You answer the question that's asked directly. And if you don't remember, I don't remember is a perfectly acceptable answer. But the prosecution thinks she's having selective memory problems, voluntarily, purposely not remembering. So what they're trying to do is they're trying to bring in what they say are prior inconsistent statements. In other words, statements she made before that don't match with what she's saying today. So they're saying, well, what did you have for breakfast yesterday? She says, I don't recall. But in a deposition yesterday or in a another hearing yesterday, she may have said, I had eggs for breakfast yesterday. So when she says on the stand, what did you have for breakfast? I don't remember. They want to bring in these prior inconsistent statements to say, well, under oath, yesterday, didn't you say you had eggs for breakfast? So they want to use those prior statements to impeach her or to show that she has no credibility as a witness. It's their own witness. And they're trying to show she doesn't have credibility when she says she doesn't remember. So that causes a problem. If they bring in their witness and they are trying to prove their own witness wrong, why did they call them? Because apparently she said something previously that they really want in. They really want to get it into evidence. So what they want to do is call their witness a liar. And while they're calling her a liar, saying, yeah, she's lying that she doesn't remember, they want to introduce these statements that she gave previously. So they'll replace her lying testimony with her previous statements. So that scenario would be like, well, you say you don't remember what you had for breakfast, but yesterday, you said you had eggs for breakfast. So you're lying about that. You had eggs for breakfast, didn't you? Well, what's wrong with that? The prosecution's view is these are not prior inconsistent statements. It's not a different answer. She's not contradicting the answer. She's just saying she doesn't remember what she said that time. And I completely agree with the prosecution. Not remembering something isn't quite the same as telling a different story. You're saying, I don't remember what the story was. So saying, I don't remember what I had for breakfast. And the prosecution trying to get her to say, you had eggs for breakfast. Now, if she would have said, I had steak for breakfast yesterday, then it would be proper for them to bring in the statement that she had eggs. Well, today you say you had steak for breakfast. Yesterday you said you had eggs. Wasn't your memory of what you had for breakfast more accurate the closer to breakfast you were? You gave this statement yesterday, not long after you had breakfast. Now today, it's a long time away from breakfast. So your previous statement, that is more accurate than this statement. That's what they're trying to do. But I completely agree with the prosecution. Defense. I completely agree with the defense that this is not a prior inconsistent statement. Jim, no spoilers, please. We don't want no spoilers, please. I don't know. I don't care if she's the baddest, just, nothing. I want a blank slate, nothing beyond what I know now. And she seems to be pretty honest. So I don't think it's a prior inconsistent statement. She's saying, I just don't remember what I had for breakfast. She didn't lie about what she had for breakfast. She didn't change her story about what she had for breakfast. So I don't think that these previous statements should be let in. The judge is kind of taking a wait and see approach, which I am now just, I'm tired of judges doing that. But, it is what it is. So that's where we are. She's still under direct examination. We're going to pick up on day 4 afternoon, which was last Thursday. Once we get going, I'll set up the poll. Any super chats that come in, we will add it to the Law Racks, Vice Racks of the Day banner at the bottom. Currently, we have one super chat from the Japanese Yakuza 1. It's 3:18 a.m. for me. Some cake. Oh, Coke keeps me awake. Coca-Cola. Almost down to bottle of vodka. Polish vodka. Polish vodka, sorry. Polish vodka, I think. A Polish vodka, I think it is. Have a nice stream. Might not remember this, but you got my support. I've noticed that the more alcohol that's consumed, the fewer punctuation marks you see. I'm speaking from personal experience. But there's there's no characters and no misspellings issued in there. So, hey, great on you. Thank you so much for the Japanese Yakuza 1, who is currently the Law Racks Vice Racks of the day. And I do have to read one super thanks that came in. So if that's the thing, if you're watching this on replay and you don't you're not able to super chat, but you really want to part with some of your hard-earned money, you can go down there and click on the super like button. It's down there somewhere. We had a super thanks of $10 from SJJ. She said, tried to send this on F at Friday stream because it was the 17th in UK. That's my birthday. Presume it didn't get posted there. It didn't get posted there, but your super thanks got posted. Thank you, SJJ. I hope you're listening. I know it's just ridiculously early in the morning for you, but I hope you hear this at some point. Happy birthday. Father's Day in the U.S. It's Father's Day on Sunday, so I have to call my old man in the morning. But I wanted to get that out of the way. All the same rules apply. We don't grift for super chats, especially not after Griftathon yesterday. But any super chats that do come in are gratefully accepted, graciously acknowledged, and humbly received. The super chats do guarantee that I will read. I will address it. I will answer whatever comments or questions you have. Try to keep up with what's going on in chat as much as I can. We'll highlight some of those as well. And I think that is all we have to do. Now, what did I do now, Rose? Did I do something wrong again? Whatever. Who cares? I misspeak all the time. Oh no, I'm not. I'm not exhausted from Evan Friday. I felt really good. I mean, I was kind of liquored up, felt good. Finished here about 6 p.m. Went, laid down, took a 3 or 4 hour nap, and then right about 10 o'clock, I decided I felt so good. I think I would go out drinking with my friends. That's what I'm tired from. I'm tired from drinking with my friends, not drinking all day with you guys. That's why the cocktail of the day is just Dr. Pepper. Whew, okay. And right before we jump in, it's happening with Harper. Give us a $5 super chat. Thank you so very much. It's happening with Harper. Says, thank you for doing this trial. I'm actually really interested in what happens. I hope you're having a great weekend. Keep on doing what you do. I will. And I don't know if I mentioned this before. I know I mentioned it in the previous fault start, but if you notice me kind of raising my head and squinting a little bit, it's because while I was taking my power nap yesterday after F and Friday, I had my glasses next to me and I rolled over on my glasses and I broke the frame. So these are the replacement of the emergency glasses, and the prescription's not that great. So sometimes I have to squint to see what's going on. That's it. All right. Well, without further ado, let's bring this up and begin the afternoon of day 4 of this trial. Here is our defendant, YNW Melly, and his weird minder handler keeper to his right, and his apparently real defense lawyers to the left of him. Oh, wow. King Ginger, member of 5 months of the Clean and Sober crew, says, thanks for being an intelligent and knowledgeable host. Happy Father's Day, sir. Also, get the popcorn ready. Oh, wait. I should have actually made popcorn. But see, no spoilers. See, now you've got me expecting something. And if nothing happens, I'll be really bummed. Thank you so much for that comment.
Oh, you wait, can you go sidebar briefly? Yep.
And the StreamYard sucks. They had this automated it would automatically star the super chats as they came in, so we didn't have to miss any of them. They took that away this morning. It's not there anymore. That feature is gone, so now I have to be extra careful that I don't miss super chats. Stupid StreamYard, stop screwing around with a good thing. The Japanese Yakuza sends another super chat and says, "You made me send another super chat. It takes me around 5 to 10 minutes to write a super while drinking just to get something correct." Well, I fully understand that. Come on, get the jury in here. Knocking the jury in.
Jury entry.
I like how they do that. They knock the jury in. Knock, knock. Who's there? Jury. Jury who? I don't have a punchline. Just thought I'd say that. Oh, that'd be a good. That'd be a good. Yeah, there's got to be a funny answer to that. Y'all keep saying his lawyer looks like George C. Scott. I don't see that. Yeah, I'm not seeing George C. Scott.
Stand. Ladies and gentlemen, I apologize for the delay. It's my fault.
Hey, Ronnie James Dio or Tiny Tim or Ron Jeremy. Back with she let her hair down there.
Proceed, counsel.
Okay, so I'm going to talk a little bit about your deposition.
Yes.
Do you recall, and you
Oh.
provided a copy of that deposition?
Oh, so they are entering her previous deposition. That's right. The judge let it in. Oh my gosh. Yeah. So I don't like this. I do not like this. I do not like allowing them to bring in her. This is not refreshing your memory. They're allowed to refresh their memory, but they're supposed to do it before trial. They're supposed to show them the documents, let them review their previous statements, let them review their deposition transcripts so that their memory is refreshed on the stand. Apparently, they didn't do that, and now they're surprised that she can't remember the answers. They didn't prepare her. She can't remember the answers. That's on the prosecution. If that's what happened, they can't. I just don't see how they can go back and use the deposition transcript on the stand to refresh her memory. But I don't like it.
Yes, I got my lawyer got provided a copy.
When you, in that deposition, were you asked if your prior
Objection.
statement,
Improper impeachment.
I heard it over. You can ask your question, counsel.
Ms. Holmes, prior to that deposition starting, were you given your prior statement to review?
What you mean?
Were
I
you?
understand. The position that I did on December 22nd. Yes, it was given to my lawyer yesterday, right before. Briefly to look at, yes.
So the deposition you that was
It was given to my lawyer
provided.
yesterday, yes it was.
So you remember coming into that deposition?
Yes, I do, I was in jail.
Okay.
Correct. And so it's clear.
Oh, yes. Sorry to pause this. Now it's all coming back to me now. I should have prepared. I should have refreshed my memory before the stream. But yeah, she doesn't even though she had the deposition and even though she read it, she doesn't remember saying what she said in the deposition. I really hate gaming computers. I have this stupid gaming mouse and it's got this emergency action thumb button on the side that goes back a screen every time I accidentally click that stupid side button with my thumb. I haven't done that in a while. That was a good one. I have not hit that thumb button in quite some time. So let's go back to where we were. How rude of my mouse to interrupt us. But yeah, so she's got the statement. She doesn't, and this is also a legitimate answer, I think. She goes, yeah, I read it. Yeah, okay. I don't remember saying that.
In terms of you don't want to be here.
You're making me be here. Yes, I have
Yes.
a house with a band on my leg. I'm a nurse. I can't even work properly. Yes.
You were under house arrest because you failed to comply with the subpoena.
No, you did not, sir.
Excuse me.
Whoa.
How we're gonna do this is you ask your questions, counsel, ma'am, listen to her question, answer her question.
Yes, I am.
All right?
Yes, sir.
Thank you.
Okay. So going back to the deposition.
Yes,
On December 14th of 2022,
yes,
do you remember coming to my office?
yes, I do.
Do you remember being asked questions at that time?
Yes, I do.
Do you recall being given a copy of your prior statement of December 12th, 2018?
No, I don't remember that. I don't remember anything, but I'm pretty sure. I do.
Okay, so what I'm going to do is permission to approach her on it,
With what, counsel?
her deposition.
Objection, Your Honor.
I have to give her an opportunity to.
I saw that.
Excuse me, there's no question pending review. All right, you can proceed, counsel.
Okay. So, counsel, I'm showing her page.
Okay, she's
10.
getting a little mouthy
Line
as a
10
witness. We don't want her to be mouthy like that. But it's their own witness that's mouthing off to them.
Okay, so just read them silently to yourself. So back on December 14th, 2022, were you asked if you need to make any corrections or deletions to the statement of December of 2018?
That's what the deposition said, judicially.
And did you indicate that there was no corrections or deletions in those statements?
I don't remember, but that's what's on the deposition.
So December of 2022, you said that this is a correct statement.
Objection.
Sustained.
So Ms. Holmes, is the December 2018 statement that you gave correct and honest?
Objection. Ask and answer.
Excuse me. You have to let, I understand you're trying to answer the question, Ms. Holmes, but when they raise an objection, you said, let me answer
Dang.
the objection first.
Yes,
all right?
sir.
Objection notice overruled. Question is the statement, can you repeat your question?
Is this December 2018 statement correct and honest?
I don't remember the December 2018 statement.
In December of 2022,
Yes, ma'am.
did you state that it was an honest and correct statement?
That's what you put in the deposition. I don't remember saying it, so I can't
Yeah,
remember.
again, that's what's in the deposition, but I don't remember saying.
Some parts of this deposition, but not all.
Okay, is there anything that you need to refresh your recollection to determine whether or not I'm being truthful and accurate as to what the question was in your answer?
I don't know to say that.
Okay.
Is that a question?
I've asked if there's anything that
Excuse
was.
me, one at a time. I just wanted to let her finish her answer before you ask the next question.
This judge is going to lose it
Is there
today.
anything that would help refresh your recollection?
I don't think so. I don't know.
Would the audio of the statement of December 2018 help?
Objection.
What's the objection?
It's irrelevant. She testified 3 times.
Excuse me, thank you. Now as to this, go ahead, overrule.
I don't know. I don't.
So, Ms. Holmes, with regards to the events of October 26th of 2018,
Yes, ma'am.
did you travel down here to Birmingham?
Yes, I did.
Who did you come with?
My daughter and my wife.
Okay, where did you go?
We went to one of Janelle's friend's house.
And whose house was that?
Frida.
And now approaching has been previously shown to defense counsel and marked as states N for identification purposes only. Ms. Holmes, do you recognize the 2 individuals in that photograph?
Yes, I do.
How do you recognize them?
I know Frida from being on Instagram from rapping. He's a rapper.
Okay, any other individual in that photograph?
My daughter's boyfriend.
Okay.
I'm sorry, I apologize, I didn't hear that.
I'm sorry.
I didn't hear your answer. Could you
Which
repeat?
one? Do I recognize?
Thank you.
I do recognize Frida from Instagram for being a rapper, and I recognize Janelle from dating my daughter.
You're at this time state we request in the states N. N is the next number of exhibit.
Any objection?
Relevance.
Overruled. It'll be admitted.
Wow.
States N, B mark states 62.
This is the photo that you can see on your screen that you just identified? Okay. So when you said Frito, is this the individual's house you went to?
Fredo.
Okay.
I knew it was you. Oh.
Ms. Holmes, how much money has the defendant's manager given you since the October of 2018?
Objection.
Whoa!
Relevance.
Whoa!
Watch from sidebar.
Whoa! They just accused her of taking money for testimony. How much money has the defendant's management paid you since the prosecution just accused her of taking money in exchange for testifying that she doesn't remember stuff? Holy crap. Yeah, I can't imagine anybody on the defense was happy with that. That's a bold ass statement right there. Whoa. It's not an improper question, but it is a bold question. Wow. Yeah, I mean, there's as it's, I mean, just as a question itself, there's nothing wrong with it. It's a perfectly legitimate question. The same way you ask your expert witnesses, how much are they getting paid to come and testify? How much are they being paid? Oh, so you're getting paid a lot of money, and that would influence your testimony, correct? You're going to testify in your client's behalf because they're paying you. Kind of the same thing. It's not the question itself is not a bad question. But yeah, I mean, I would be objecting like a mofo, like the defense is. And wow, we'll see what's happening. Now, again, spoilers to a minimum here, people. I want to look at chat, but you know, no spoilers. Don't let me know if it's going to get better than down the road. Don't let me, because then I expect it to escalate. Just pretend you know nothing beyond this. You don't know if it gets better or worse down the road. You don't know what happens later. Just, you know, there you go. Wow. Whew, that was a bold move. Golden rule thing. The golden rule is, you know, the prosecution can't make any statements that would be considered as saying that the defendant doesn't have a right to remain silent. That would be like, well, you could have come in and told us what really happened, or we asked you what happened and you didn't tell us what happened. So you know, you can't comment on the defendant's right to remain silent. Is basically what the golden rule is. This doesn't affect that. This is the witness. They're just basically saying the witness was paid off. And this is a long sidebar. If sidebars go this long, they're either the lawyers are either arguing fiercely back and forth to a judge who's maybe indecisive about something, or the judge is getting upset.
How much money have you gotten from
She won. She won that question.
with regards to
Why don't we have any volume, Court?
Ms. Holmes, you have formerly had a credit union attached?
Oh, come on, Court TV. All right, let's go back a little bit so we can bump the volume.
How much money have
Because Court TV drops the volume during the sidebar, and then they up the white, because they up the white noise in the courtroom. Court Law and Cuck, we got to put up the Law and Cuck stream here eventually. Anyway, Law and Crime, they reduce the volume, and then when the sidebar is over, they put their volume back up. Apparently, they didn't put it back up, so I am going to boost this about 500%. Now, mind you, when that volume comes back up, it's going to be loud, so be prepared for a huge increase in volume when Law and Crime figures out that they didn't reboost their volume. So she's going to ask again, how much money did you get paid? Before we do that, though, let's hit the super chat from TR Greater X1. Good evening, Jeff. Glad you're still alive after last night's stream, Law. Really enjoying the trial coverage. Keep it up, brother. Thank you so much for that generous super chat. So deeply appreciated. Someone asked how far to Doggo Cam. We're almost halfway there. Living on a prayer. All right, here we go. Let's see with this answer.
How much money have you gotten from the defendant? Melly and Smith?
None.
And
Okay.
with regard to that specific statement.
Now that's a problem. See, now they look bad. They've accused her of taking money in exchange for her testimony.
From like a credit union account?
This is launch credit union,
Okay. And at Launch Credit Union, you banked there for a number of years.
many years.
The credit union that you've been at, it's been your account, and I won't put your account number on the record.
You know, I object to this line of questioning based on the court's ruling.
So the.
Okay, the court made some ruling.
Never
Sidebar.
been given money whatsoever.
I've never been given money for personal use.
Okay. So the question is, how much money have you been given by the defendants?
For vacation for all of us, for him, his wife.
There we go.
To pay for it as far as, he gave me $5,000 for Airbnb, which I gave him $1,000 to deposit that,
So he did give you money.
not for personal use.
Okay.
Excuse me, can we clarify who he is,
Objection.
Jameson Francois?
Objection, or just clarify, counsel.
So it's clear, who is Jameson Francois?
He's Melly's manager.
And you mentioned his wife as well. Who's his wife?
I used to go by AA.
So AA and his wife.
We were all good friends.
So I'm just looking now, previously shown to defense counsel and marked as states triple M. It's a composite of 17 pages. Did you have an opportunity to review that prior to coming into court today?
Yes, I did.
Okay, and in terms of the individuals and the phone numbers that are on that, do you recognize your own phone number?
No, I do not.
Okay. Going forward through the contents of that particular item, do you recognize the conversation about a snake?
No, I do not. I know they had a snake, I don't recognize this conversation.
Okay, with regards to the conversation about the snake that you do remember, what do you remember about the snake?
That they had a snake.
What happened to it?
Objection, relevance.
Sustained.
What the hell does a snake
Maybe it's upside down.
have to do with a murder? It wasn't murder by snake. All right, prosecutor is asking some weird ass questions. They're asking about a snake and what happened to the snake. Yeah, irrelevant. And I think the judge is starting to get irritated with everybody, with the witness, with the prosecution, and with the defense. She's never been given money for personal use. I don't know. I mean, you might be doing something. Who knows? That would be a question for redirect. I mean, recross or cross-examination. Sorry. It's weird when the prosecution is taking an antagonistic approach to their own witness. It's kind of hard to figure out what's going on. So that would be a question under cross-examination. So now the defense is essentially becoming the witness's friend, and the prosecution is becoming the enemy. So that would be his thing on cross-examination for the defense to come and say, okay, now what do you said not personal use? What did you use it for? So we'll have to wait for cross-examination, I think, to find the snake food. The defendant's manager gave her money. I said $5,000 for an Airbnb and something else, but it wasn't for personal use. We'll have to figure out what that means as this thing proceeds. I have no idea. I have no idea what it means. Jim Satala, no spoilers, please. Jim, please do not we're just speculating here. Please, no spoilers. It doesn't come out in court. If it doesn't come out in court, it doesn't happen. It doesn't happen. Well, the only thing that happens is what comes out here in court in front of the jury. So extraneous news stories, all those that affects how we view this. We're focused on the evidence that's here at trial. Why wouldn't it come out in trial? But anyway, that's weird. Somebody should have asked this. If they didn't, it sounds bad, but whatever. Nobody knows what's going on here, and and they're having this little giggle fest again. They're having this little giggle fest between he and his minder, his handler. They giggle back and forth a lot. John Gordon asks how much further till doggo cams. I mean, there's if you want like actual numbers, like $47. The Japanese Yakuza 1 sends another super chat. Gonna take another coffee and another glass of vodka and cola. Gonna head to bed with you in the background with your sweet soft voice. And everyone stay away from drugs, unlike me. No, you should stay away from drugs too. Everybody should. Absolutely everybody. Well, Jim, just don't tell us anyway. Just don't tell us anyway, Jim. I must admit the thought crossed my head, but that thought went through my mind. But I would never do that to Jim. I would never do that to anybody, really. No spoilers is not one of the 10 commandments written in stone by the finger, or one of the 3 law racks commandments written in stone by the finger of the law racks. But no, it's just a suggestion. Well, thank you, Susan D, for that. She stood up. Holy shit. Ludo stood up and went over to the, wow. Did she just actually do something lawyerly? Sorry, Susan D, didn't mean to cut off your comment. I was just surprised by Ludo from Labyrinth actually moving. Wow, Legal Vices, happy Father's Day. Thank you so much. Hey, Jim, somehow I empathize with that. Wow, Ludo moves. Yeah. JKD Buck knows what's up. Ludo friend. Exactly. Ludo friend. Smelled bad. All right, this is Judge is getting after people here. This is going along. Judge is upset. Oh, there you go. Wait.
Ms. Holmes, I want to ask you a question as to what was your daughter's phone number back in October of 2018?
I have no idea, I don't know.
Is there anything that would refresh your recollection as to what her phone number was?
No, because I don't remember mine.
You don't even remember your own?
Yeah, no, I don't.
You don't even remember your own daughter? Okay, look. God dang it. I don't want to keep hitting this pause. We'll never get through this. This is a legitimate answer. If you put a gun to my head right now and said, "What is your son's phone number?" you'd have to take me out. I do not know my son's phone number. Why don't I know my son's phone number? It's saved right here. I go, oh, gee, boom, go to my contacts. Type in or scroll down because he's on one of my starred things. Hey, wow, there you go. There's his phone number right there. So not remembering your child's phone number is not, and she's got that bitch please look on her face. It's not a thing to not know to have your child's phone number memorized. That's what speed dial's for. That's what your phone is for. Come on. Anyway, well, before we get back underway here, the Japanese Yakuza one. I'll promise this is the last chat. No, you don't. Keep sending it if you want. Don't keep accepting them. I will take a break from the fun stuff for 6 months to a year now. If another special occasion occurs, I'll do. No, none of that. Don't do that. Don't do that. Don't do it again.
Did you review your statement of December 18th of 20, I'm sorry, December 14th of, December 12th of 2018? Did you review that statement prior to testifying today?
Yes, I did.
And in that statement, were you asked, what is your daughter's phone number?
Right.
Objection.
She may have remembered it then. She doesn't remember it now.
If I were to show you the statement, would that help refresh your recollection as to whether or not you were asked that question?
I don't think it would, but you can show it.
You have permission to approach?
Yes, ma'am.
Okay.
King George 333 says this lady is a
Okay.
stone cold liar, in my opinion. Also, free the doggos. We're inching closer.
Silently to your son?
Well, she's either a liar or she's answering the questions very, very directly. So we'll just have to see what comes out on
Okay.
this
Looking
weird
at that,
cross-examination.
does that refresh your recollection as to what your daughter's phone number
I
was?
still don't recognize the number. It doesn't for me, but I don't know if that's her number. I don't recognize the number.
Okay, so you don't recognize the
Yeah,
number.
like 3 daughters, so I don't know.
Understood on that one. So, should I permission to treat the witness if possible?
Objection. Want you to sidebar, please?
Oh my God. This is sidebar heaven. Good grief. At some point, I'm speculating. Again, no spoilers. At some point, the judge is going to. Oh, hang on here. Yeah, that's what I was going to say. I was just going to say this. I was just going to say, with all of these sidebars coming up every few minutes, at some point, the judge is just going to put his foot down. He's going to excuse the jury. And he's all right, let's just have all of this shit out in court right now. Let's have we're not going to keep doing these sidebars. All of these issues, let's hash them out right now, outside the presence of the jury, on the record, etc. And that's exactly looking at the subtitles, looking at the closed caption. That's exactly what's just going to happen. Sometimes I feel validated.
Do not discuss the case.
Yep. Here it goes.
I want to discuss the case from your presence and certain research. There's no paper on your jury.
This is the judge going, all right, we're gonna have it out. Everybody put your cards on the table and let's dance. Trigger of Oz, what's up? Is this a better time for you? Is this a better time for you, Trigger of Oz? Do you like this time on the weekends?
Thank you. Let the record reflect the jury stepped out.
I like the witness so far.
Name along with the defendant.
Now, if she's lying, she's evil and devious, but not feeling,
No, I was
not
told to bring
feeling the
one.
lies yet.
So, you want to speak to your attorney? Any
Yes.
objection to that?
Yes.
If someone is officially designated as a hostile witness, you can ask leading questions.
Was already been sworn and it's in the middle of testimony, and she goes and talks to her lawyer. It's type of intimidation, coercion. I think the rules that so we do object to that. It's intimidation.
Well, let me ask you this. Is it something you think you need to talk to your lawyer about?
I'll talk about it. I don't think I need to, but.
Hang on, I need to back up. I didn't catch that.
You want to speak to your attorney? Any objection to that?
Yes,
What's
yes,
your
Your Honor. The witness is on the stand, and for the state to suggest to a witness who has already been sworn and it's in the middle of testimony, that she goes and talks to her lawyer, it's type of intimidation, coercion. I think the rules.
This is getting out of hand. I've got it. It's I must have missed it, but the prosecution apparently told the witness that you might want to go talk to your lawyer. Implying, at least to me, you are lying under oath. You could be prosecuted for perjury. You may want to go talk to your lawyer before you lie anymore on the stand. That is the implication that I get from that statement. So that's what, and he gets that same vibe. That's what he's saying, to tell her after she's been sworn, to tell the truth, the whole truth, and nothing but the truth under penalty of perjury. And after she's been sworn there, and you tell her she might want to talk to her lawyer before she answers any questions, that's intimidation. I agree. I like that. I like this. This defense lawyer is good. He is a good, sharp lawyer. I like this guy. So yeah, she's saying the state is intimidating the witness by telling her that she might want to talk to a lawyer before she answers more questions. Parentheses, because you're lying under oath and we could prosecute your ass for perjury. Mm-hmm.
So we do object to that. It's intimidation.
Well, let me
I
ask you
agree.
this. Is it something you think you need to talk to your lawyer about?
I'll talk to her. I don't think I need to, but I don't know what the problem is. I'm answering her question like she wants. I'm not sure what's going on.
Well, so my question to you is, do you want to talk to your lawyer?
Yes, I will talk to her.
All right, so we're gonna be in recess. You talk to your lawyer, and you go ahead, you step outside, all right? And
I've never seen this
The
before.
argument here with the attorneys.
I have never seen this before in my entire life, where the state tells the witness she might want to talk to her lawyer, and they stop the trial so the person on the stand can actually go outside and talk to her. I've never seen this before.
You're asking me to declare her a hostile witness. It appears to me she is. I don't know if that's what your position on it. She's at, that would allow her to ask these legal questions as she suggested sidebar. The problem with any of the questions, though, I don't want you to be asking specific questions, that things that she said previously she doesn't remember. And
Okay, so now she has, up to this point, she was not officially a hostile witness. Now the judge has just made her a hostile witness. So now it essentially flip-flops. The prosecution is now cross-examining their own witness. So they get to ask the leading questions. Now the leading questions can come in. And now the judge has pointed this out. It seems that they talked about this on sidebar. If she doesn't remember, she doesn't remember. I don't want you to ask her questions about the things that she's already said she doesn't remember. So don't backtrack and go, yeah, you just said this. You said you didn't remember this. Leave it there. Yeah, to declare someone a hostile witness is basically they're our witness, and now they've turned hostile on us. Now they're not telling us what they told us before, or now they're contradicting themselves, or now they're just being belligerent. They're being hostile towards us. So we want to be able to attack them. They're basically attacking their own witness, and that allows you to ask the leading questions and other things like that. So yeah, just basically, it literally just means the witness has turned hostile on you, and now you can treat them as if you were the other party and cross-examine them and whatnot. What time is it for me? It's 11:04 a.m. on a beautiful, beautiful Sunday morning with the birds chirping, and that's why we decided to do this stream here. So after the stream, I got to go do some stuff. I'm just going to go for a nice long walk because it's a beautiful, beautiful day. Yeah, so I like this. This is a good trial. The first 3.5 days, the first 3.5 days suck, but this is a good insight. This is good lawyering from the defense. This is good decisions by the judge. I don't like the idea of using this previous statements at all, but good, solid ruling from the judge on everything else, I think. And the defense lawyer is doing a great job. The witness is interesting. So let's see how this plays out. But I like this. I like what the judge is saying. She's a hostile witness. You ask leading questions, but don't ask her leading questions about the stuff she's already said she doesn't remember.
Specific questions, that things that she said previously she doesn't remember, and that you're just going to go ahead and put testimony before the jury. I mean, that's, it's not the attorney's questions that are in evidence. I mean, if she doesn't acknowledge it, or even after asking leading questions, she basically said,
Oh.
She doesn't know, or that's the end of it. I mean, you can't go much further than that. You can't put in evidence. Didn't you say X, Y, and Z to the police officer? She's not acknowledging she said it. I can't see, how you do that. You can't.
So I think I can ask the questions because
What
of
question?
in terms of, did you provide this phone number as the number for your daughter? Did you provide this number for the phone number regarding Mr. Dennis? Did you provide this information,
What information?
whatever the particular statement may be that we're at that point in the questioning? For example, did you provide the phone and say previously that you talked on FaceTime with the defendant? That you talked to him on the FaceTime on the 772-713-9807 phone number? So judges, in terms of if I'm going to then impeach her with some other outside statement or some other prior consistent statement that she has made at some other proceeding, at that point, that's the concern as to her perjuring herself on that. So I think that's why.
Okay, now they are flat out. She has just been flat out accused of perjury.
In terms of the prior statement on that, I still maintain that she has endorsed its authenticity and accuracy. Your Honor was provided with a copy of that deposition that the state referenced when we were talking about, and she indicated she was honest and truthful in that deposition, and she then endorsed the prior statement. So the prior statement should be allowed in on that, and if there's no concern as to any improper or anything on the jurors, because they will be instructed, as they always are, that no statements by the attorneys are evidence.
Yeah, okay. Yeah, I don't like this prosecution at all. Don't like it. Don't like it. Don't like her. Don't like her. Because the judge said what I just said earlier. But I like how he said it. He must be a judge or something. He said the attorney's questions are not evidence. So you don't try to introduce evidence through your questions. And I like that. So that's why you say, going back to the analogy I used at the beginning, what did you have for breakfast? I don't know. Well, in your previous testimony, did you say that you had eggs for breakfast yesterday? Or, in your previous statement, you said you had eggs for breakfast, correct? It's just, I don't remember. Now, she's just answered the question, but the jury heard the lawyer's question, saying, well, you previously said you had eggs for breakfast, correct? And so the jury has heard from the prosecution's mouth, oh, she had eggs for breakfast yesterday. And the judge is saying you can't do that because she already said it. It's not going anywhere. But now the prosecution is again saying, oh, no, there's the jury instruction that says what we say isn't evidence. Only her answers are. But jurors still hear the prosecution say, you said you had eggs, correct? And the jury's not going to go, well, wait a minute, I'm going to completely disregard that I heard that. That's not how it works. And she knows that. She knows that. She knows that legally, her question that you testified under oath previously that you had eggs for breakfast, correct, is not evidence. She knows legally that's correct. But practically, the jury is going to hear it as evidence. She knows that. Don't like her. Don't like this tactic. Don't like it at all.
Mistrial?
Yes, please. Your Honor, first of all, the state is now conflating issues. What we objected to and alerted the court to because we knew that this debacle was going to take place, I think it is evident that, yes, it appears as though the witness is not a major fan of the state. That's true.
Nice.
The state knew that going in. This is no surprise. These cases use the very language, surprise. In other words, what the state intended to do under a ruse, an 803 90.803, section 5 ruse is put on the witness to impeach that witness for that sole purpose of impeaching the witness, to introduce an
Right.
out-of-court statement that is inadmissible because the state understood that she recanted. The state, under the pretext, oh, we don't know that she's
Yes.
hostile. We just think her recollection is failing. And we believe under 90.803 subsection 5, we can just read her statement. Unfortunately for the state, the Supreme Court has made it extremely clear that that witness has to vouch for the accuracy of the statement at the time it was made. And the Supreme Court also said in that context that in the context of an 803.5 exception, the contents of the record substitutes for the witness's testimony. This means that the reliability of the assertions rests upon the veracity of a witness who is present and testifying. The state is calling into question her veracity and calling her pretty much a liar, saying that she's feigning recollection and now attempting to essentially introduce a report of a police statement into evidence by the state testifying, asking the court to let the jury know that all this stuff that we're about to say, upon which we want to rest our case, is don't take it from me because I'm just a lawyer saying it. But then there's no point in saying it because there's no way to get it through this witness. She can't put her on to impeach, which is exactly what she's trying to do. The 803.5 is a ruse, and that's not working out. And now she's doubling back to the original, which is let me call her hostile so that I can lead. And instead of eliciting the testimony from her, I'm going to read it out of this report.
Absolutely.
And say, didn't you say that? So what happens is we're going to now be in a situation where when she's asking the state to tell the jury, hey, what the lawyers say is not evidence. So
clearly this man is a genius. Clearly this defense lawyer is a top tier Mensa level genius because he thinks the way I do. So clearly this man is of the highest intellectual caliber and is a master of his craft. Clearly. I like the way this guy thinks. What a freaking genius this man is. And again, I know because I just said this.
it doesn't matter that this witness is going to say, I do not remember that number that you just read to me. That you just let me see. I told you I don't remember it. So I now the state wants to come back to the podium and blurt that number out. She just said she doesn't recall it. So what's the point of saying it other than to introduce it into the record?
The jury is out of the room. They're arguing.
Attorney's lips. So rules don't allow her to do what she's trying to do.
Thank you.
So you're in further support of treating a witness as a hostile witness. This has previously been provided to defense, but this is the Instagram production for Miss Felicia Holmes that I'm showing the court now that she is previously identified as her specific Instagram, and that it is saying the promises that were made to us by YNW for me to quit my job and they would take care of us were all lies. They didn't want us talking with prosecutors, but now they have all disappeared. I quit my job based on what Trapp and his wife or company said. Now look, we can't go home. We're spending all my money I worked for and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. I'm not holding anything back. I'm doing what I should have done in the beginning. They can call me Miss Snitch Bitch.
That doesn't look very good. That doesn't look very good at all. Holy crap. Again, the jury hasn't seen this yet. But but if the jury sees it, this is bad. The promises that were made to us by YNW, I'm assuming the defendant, for me to quit my job, and they would take it with the YNW, like his production company or whatnot, they would take care of us. Quit my job, they'll take care of us, were lies. They didn't want us to talk with the prosecutors, but now they've all disappeared. I quit my job based on what Track and his wife or company said. Now we can't go home. We spending all my money I worked for, and they taking trips and enjoying life. If you think I was a beast before, wait until this trial. They can call me Ms. Snitch Bitch. Well, Zelke, that's what we're here to talk about. That's what we're arguing about. Because this is probably exactly what we're arguing about. This thing here. Yeah. And literally this is the whole thing. The defense is saying if she can't remember it, if she can't remember making this statement now, if she can't remember sending this text now, you just can't say, did you say this? I don't remember. Okay, jury, disregard this question based on this text. This is literally what they're arguing about right now. Wow. All right. This is a pretty bad text. I will admit, this is a pretty bad text. And if it's not allowed in, I'm going to have to unsee it whilst considering whether or not to find this person guilty, which is the problem. Wow. All right.
So, Judge, it's very clear from this record that my intention and what the witness has represented to me in all shapes and forms that she was going to be honest and truthful. So to say that it's improper for calling her just for the purposes of impeachment is incorrect. So to continue on in that same Instagram production, and this is in June of 2022, Felicia Holmes is saying, they made me quit, told me that they would take care of us until trial was over. But guess what? Lies as usual. I was making $9,000 weekly.
Jesus.
I didn't need shit from them, but everyone begging and pleading.
How is a nurse making $9,000 a week? How is a nurse making $9,000? That's got to be $900. That's got to be. How? If nurses, we got nurses here. Rose, are you here? Nurses, come on. Tell me this is insane. Damn. Okay. Please tell me that's before taxes. Because if someone here is making 9,000, even before taxes, I'm in the wrong damn line of business. All right. Huh. Traveling nurse. I guess. As we've said here, dang. Yeah, all right. Whew. People become a traveling nurse, apparently. Wow. All right. That's good. Thank you for educating me on that. I mean, that seems ridiculously high to me, but hey, that seems to be possible. So cool. All right. God bless this woman.
Now they all ghost. I got something for Track, though. You lied to me and my child for the last time. again, saying that you're going to air him out to the prosecutor.
Yeah, I'm airing his ass out to
The
this.
judge,
Doesn't
in
sound
terms
good.
of, so that's in defense of the representation of counsel that is just being called for impeachment. It's also clear that this witness has received multiple benefits from the defendant based on her own statements there, that she has endorsed that that was her Instagram on that.
So, counsel, there's a couple things going on here. Number one is you indicated that it was the testimony was going to be admitted because it was in essence, I forget the statute number,
9803 sub 5, it's a past recollection recorded.
as recollection recorded, and you
Correct.
gave me the polite case,
Yes,
and that indicates that you have to have a proper foundation, but it has to be.
Yeah, well, he's Johnny
not
Depp.
only, there's a proper foundation, but it has to, the hearsay statement was inadmissible in that case because the witness did not vouch for its accuracy or correctness, which is what we have here. The witness isn't vouching for the correctness or accuracy of the statement. So it doesn't meet that criteria. On the other issue about impeachment, this is not what she said. She's, she said, gave me a different answer. What I tried to read before was something from a couple of cases. And again, the synopsis at the end of it, this is, I'm just reading again from the SL, a child case, the state 993 Southern 2nd, 1108. It just says the Florida rules of evidence provide that prior inconsistent statements are admissible as substantive evidence if the declarant testifies at the trial or hearing subject to cross-examination regarding the statement, and the statement is inconsistent with the declarant's testimony given under oath, subject to the penalty of perjury at a trial, hearing, or other proceeding, or in a deposition. Goes on and says, interpreting this position, the Supreme Court of Florida recognized that a statement given during a police investigation is not a statement given at an other proceeding. So then if you agree, I don't know where we're going with this, counsel, respectfully. It seems to me under either scenario, that statement doesn't connect. Now, I do have a message from Mr. Bears, BE.
Okay, he's just said that statement. Those messages don't come in. All right, good on him. Good on him. Just for the two reasons he gave, which are two reasons I completely agree with.
RES. He says he's Ms. Holmes' attorney. He would like to speak with me. I don't know what he wants to talk with me about. He candidly, I'm assuming is this testimony. But anything he could say right here in open court, I don't have an issue with that.
That's fine, Your Honor. I really question the purpose in advising my client, Ms. Holmes, to consult me for a lawyer. I take that as an
Lawyer is going to go after the prosecutor here now. He's going to go in on her for threatening perjury.
implicit threat to Ms. Holmes. We have an agreement that she comes in here today to testify. She's done that. She's honored her agreement. And, she's answered all the questions put to her. She may not be answering the questions to the satisfaction of the state, but she has fulfilled her agreement. And now Ms. Holmes is again placed in fear. And that's all I have to say.
Thank you.
Oh, that wasn't very
All right,
passionate.
let's,
You should have gone in on the prosecutor.
Anybody need a restroom break room? You ready to go?
yes, sir.
Pardon me?
Judge, I think someone on the fence.
I need to.
Sure. We'll take a short recess.
All right. Wow. So they're gonna go take a short a 10-minute break. That's not very short. Why the fuck is this guy like this? Come on, dude. Why are they? No, the jury's not there, but still. If I was on trial for, maybe I'm projecting. I don't know, but if I was on trial for double murder, first degree murder, and facing the freaking death penalty, I probably wouldn't find anything funny ever until this was over. I don't know. Who knows? Whatever. The black defense attorney is Jason. Where'd that go? Jason Williams. The other guy, Bradford Cohen. I'm a huge Jason Williams fan. This guy is good. I really do like this. Again, if you can afford them, this is what you get here. All right.
And I think the state has demonstrated that the only purpose for which they want that witness there is for the improper purpose. And they're compounding the prejudice by having her remain there. I think if the state has something that's admissible that they can prop to this court, that witness needs, testimony needs to be concluded.
Thank you. They were here.
Judge, the state's on.
Pardon?
There's additional information and things that's open to being talked about.
Thank you. So this is my thought, counsel. I don't have a problem declaring the witness to be hostile to the state and allowing you to ask leading questions. I'm okay with that. I think that's been established. She's wearing an ankle monitor that was put on there by the state. I guess pursuant to this hearing where she was, I think you said she was in Islands.
Yes, sir.
Regardless, so I'd allow that. The problem I don't want to happen, so we're clear, is I don't want you to regurgitate things that are in her statement that she's not, that doesn't comply with either of the two rules we've been going over. So I don't want you to be saying, well, didn't you say to, the police officer, Mr. Moretti, or whatever, the officer's name is Detective Moretti, that you saw them on FaceTime or whatever it was, that they're on that date when the incident in question happened, and Mr. Demons told you X, Y, and Z. All right? The witness hasn't subscribed that the statement was accurate, so it's not getting in under recorded recollection, and it's not getting in as impeachment because it's not, it's a police investigation, not a deposition testimony or something along those lines. So
don't
get in the way I read the rule under either of those two sections.
So is your
So I don't
understanding?
want you to get in the back door, but you can't get in the front door.
No, just
Yep, don't want you to get into the back door, but you can't get in the front door. Right. That's it. Be honest, be upfront with it. And he's saying you can't introduce this. Apparently, she said something to the police in this police report. He's saying you can't use the police report to impeach her because the police report is not, it hasn't been properly entered into evidence, and it hasn't, it's not a prior inconsistent statement of hers, et cetera, et cetera. You can't use that. Don't make those statements that are in this police report. Don't bring them up.
to make it clear, is Your Honor holding or stating that a police report cannot be used to impeach someone?
No,
Or-
I didn't say that. What I said was the statements in the police report, right? You can't just have that, read that back to her. Didn't you say this to the police officer? I don't want that being done. I don't think that's appropriate. She says she doesn't remember the statement, doesn't know it's accurate. She didn't rely on its accuracy. And
Understood. And I just want to make sure it's also clear, under 9803 sub 5, the past recollections reported, there's no requirement in any of the case law or statute that the statement be sworn on that. If you look at that, because if there's other statements this witness has made that she may endorse as being truthful and accurate, and I'll have to ask her on that, then those are possibility of other ones that could be put in.
Nope.
Your Honor, among the statements that we would like the court to forbid the state from asking in a leading fashion are the phone numbers or anything that she said to the officer on the day in question. What's the date that statement was made?
December 12th, 2018.
Nothing from that statement should be.
She'll ask whatever question she thinks appropriate. You make your objections, but I don't think it's appropriate to be asking, didn't you say this? X, Y, and Z. I don't think that's appropriate because she's not subscribing that this.
So no,
the
didn't you say this question?
statement was truthful, so I don't want you to just be regurgitating the statement. And asking her that, I don't want that done, and I don't want you to do, anyway, that, we'll see where it goes.
Yeah, just one thing, Your Honor, I'm sorry to belabor the point, but I want to make sure that the state doesn't confuse the court's ruling to be one of form over substance. And instead of saying, didn't you say this, say, isn't it true that? Or anything where the content
Any
of that
form of that
report
question.
are uttered out of her mouth that she knows this witness had not adopted. And she's gonna get a no, and she's just putting it into the record. It's improper. And I've
Hopefully I
asked,
made myself clear, but that's why she's gonna be able to, counsel's gonna be able to ask whatever questions she deems appropriate. You make the appropriate objection if you think it's objectionable. I'm just gonna rule her to go forward like that. I don't know what you intend to ask, counsel. I just don't want it, the
Kerfuffle,
contents
what's
of
up?
that statement, regurgitation of that in some form of leading questions, all right? I'll bring the jury in. Let's get the witness back in.
All right, the jury's coming back in. Wow, let's see where this goes. He's laid down the law. No questions. Did you say this or didn't you say this? Or all right, can't bring in the police report. Her statement to the police in the police report. TR greater X1. I don't know. I might be laughing. Gotta laugh the pain away. I'm a semi-truck driver, so I can't drink the pain away. Yeah, never drink the pain away. That's not a thing. All right, so she's been declared a hostile witness because she's not playing by what the prosecutor wants her to play with. Yeah. She's arguing. She's allegedly contradicting previous statements and not cooperating the way that she apparently told the prosecutor she was going to cooperate.
Come on, Ms. Holmes.
Okay, good. They brought the volume up here.
Thank you.
TR Greater X says, but what about subject matter jurisdiction? Ground. Somebody delete this comment, please. Just kidding, Valhalla. Got that little poofy thing going there in her head. Got her loofah hair.
Jury entering.
No spoilers in chat, please. No spoilers in chat.
Ladies and gentlemen, thank you. Please be seated. Let everyone see and reflect the presence for a jury. This is part of the notice to the council. Ladies and gentlemen, jury.
Okay, and this mic cutting in and out is really starting to bother me.
Yes, sir.
Please.
Okay, Ms. Holmes, when we left off, we were talking about a pet snake.
Yes,
Do you remember there being a pet snake?
I remember you talking to me about it yesterday.
Okay. And with regards to that snake, you recall it unfortunately passed away.
I'm pretty sure probably, I'm not sure it's not here, I'm pretty sure.
Wait, did she just say
Remember the
that?
name?
Did she just say the snake unfortunately passed away? I hope I heard that right because that's the nicest thing that anyone ever said to that little snake. All right.
Name of that pet snake.
No, I don't.
In terms of the owners of that snake, you remember who owned it?
What the hell does this have to do with anything?
I just know it was, I know who the owner was, it was in the house with Mariah lived.
Where did Mariah live at that time?
She lived in BMR.
And do you know the address?
No, I don't.
Who did she live with?
She lived with a boyfriend, but you know.
It would. My sister has a lovely little snake called Mango.
Are you telling the ladies and gentlemen of this jury that you don't remember your phone number in
I'm
October
telling you guys,
2018?
I do not remember my phone number. I don't remember.
And are you telling the ladies and gentlemen of this jury that you don't remember your daughter's phone number?
No, I do not remember my daughter's phone number.
And there's nothing that would refresh your memory or recollection whatsoever?
Objection,
That's
asked
4 years
and
ago.
answered.
Yeah, I was gonna say I thought she wasn't allowed to ask those specific questions. I thought were prohibited by the judge.
Overruled.
What?
That was 4 years ago. I've had so much trauma in my life since then.
Of course. So, is it fair to say that you were worried about Melly when you came down here to Fort Lauderdale on October 26, 2018?
Was I worried about him? Yes, I was.
You were worried about him because he had just been involved in a drug fight.
No, because they said his friend had been in the trial.
And you were worried about him because he was hiding in some bushes.
Objection.
I don't remember his
What?
bushes.
What do you remember?
I sustain the objection.
What do you remember?
I just remember him saying for us to come get him.
When you made contact with him later that same day at Frito's house?
Yeah.
Is it fair to say he had no blood on him?
No, he didn't have any problem.
And is it fair to say that he left Frito's house and went up to a video shoot that afternoon evening?
Yes, I did.
Did you go to that video shoot?
No, I did.
Did Mariah live with Mr. Dennis after the homicide for a period of time?
Yes, she did.
Did she live in a condo in Miami with him?
Yes, she did.
Okay.
David Howard is apparently the lawyer's name. So I like David Howard. David Howard is a good lawyer. Great lawyer.
Have you made other statements about the events of October 26th of 2018?
I don't remember making any other statements.
Do you recall a Instagram conversation with the co-defendant Cortland Henry?
I don't remember it.
Oh,
Okay, if I may approach, I'll see if this refreshes your recollection as to that conversation. It's 3 pages.
Is that the mark, counsel?
Not yet, Your Honor.
no spoilers, please. Chat. I don't want to see these things.
I don't remember it. I don't remember it.
You don't have any recollection of that?
I don't remember it.
Is that your Instagram, LaneQueen258?
Yes, it is.
Okay, and the conversation that you don't recall on that whatsoever?
Yeah, I don't remember it.
Okay. Is your testimony here today that you lied in those statements?
That I lied in my statements.
The allegations that you made to Mr. Henry?
And I don't make those allegations, so I don't.
Do you remember sending screenshots of those allegations to a detective?
I remember sending a detective something stating that I didn't threaten Portland.
No.
Because I remember that.
You remember sending screenshots of conversations?
I remember telling him that I did, because he reached out to me, asked me that I threatened to kill Portland. And I said, no, I did not threaten Portland. I remember that.
Was there any threats made to you by the defendant?
No, not at all.
In terms of your daughter, Mariah, where is she?
I don't know.
After this incident, did she live with the family of the defendant?
She's always lived down there. Before this incident, she always lived there.
And the It's your testimony to the ladies and gentlemen of the jury here today that you saw Mel Demons October 26, 2018.
Yeah, I saw him.
That you spoke with him and heard him on the FaceTime conversation.
I did speak to him, yes.
And it's your testimony that he indicated that it was some sort of shooting that occurred.
Yes, I did, yeah.
Okay, and it's your testimony that you saw him on your daughter's cell phone as a video call.
I saw him.
Is it your testimony today that after that you called Jamie King?
Yes, I did call Jamie.
And in terms of the conversation with Jamie King, that occurred
Yeah,
immediately after the FaceTime?
not probably immediately, but sometime after. Not quite sure the time. I don't remember what time it was.
And it's your testimony to the ladies and gentlemen of the jury today that you were dishonest in your first statement?
I don't remember my first statement.
Dishonest in
Is
the
it your
first statement?
testimony to the ladies and gentlemen of the jury that you would
I don't
lie?
remember my first statement. I have no reason why you.
Yes or no? Did
No,
you lie to police?
I did not lie to you. No.
Yes or no, did you lie to police?
I didn't lie to you. I don't remember my first statement. You're trying to make me say I remember my first.
Okay, we're walking close to the line here with what the judge talked about not being able to bring in the police statement. So what they have to do is, one of the things they have to do is prove that her statement was true and reliable at the time she made it. The time the original statement was true and accurate, they have to show that it was. They just can't bring in some random past statement and use it as evidence. They have to show the veracity, the truthfulness of the statement at the time it was made. So that's what they're trying to do here with this questioning. When you said this to the police, when you made this statement to the police that we can't put into evidence because we don't know if it's true or not, were you telling the truth? Were you lying? So now they can say, see, she said what she told the police were true, so now let us bring the police statement in. That's where they're trying to go with this.
First statement I did. For me to say no, I didn't lie with me. I remember my first statement. I don't remember it, so I don't remember.
Well, if you need more time to look it over, I have a copy of the.
I looked it over. I still don't remember it.
Okay, well,
I did it over 100 times. I don't remember.
well, if you'd be so kind as to do it one more time.
Yeah, sure.
You can say that to this jury
I don't
that this
remember
is not truthful.
Yes.
This objection asked and answered 5 times, Judge.
Take objection noted. Move.
Yeah, I honestly God did not remember any of this on here. Like, I don't remember talking. I don't remember. I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your own practice to lie to law enforcement?
Objection.
Excuse me, can I
I'm
see
very
side
good
door?
on.
Quiet, please.
Whoa. Wait, hang on. Hang tight again. Sorry. Hang on.
Yeah, I honestly God did not remember any of this on here. Like, I don't remember talking. I don't remember. I had a hard time that year, so it's a lot that I don't remember about that year.
Is it your own practice to lie to law enforcement?
Objection.
Okay, yeah, that's what she said. Is it your practice to lie to law enforcement? That's almost the have you stopped beating your wife question. She says, no, it's not my practice to lie to the police. Then they can go, well, did you this time? Or are you telling the truth this time? But if she says, yes, it's my, yeah, that's a bad question.
I'm very good on.
Quiet, please.
And the judge is getting grumpy. And the defense is getting grumpy.
Is it the transcript that you're saying is not accurate?
Sustain.
Jesus.
Excuse me, I sustain the objection.
Okay, so going back to the relationship with your daughter and the defendant,
Yes.
how long did that last?
3 years. I'm not quite sure how.
During the course of that relationship, did she have multiple photographs of him?
I'm pretty sure she did.
Videos?
I'm pretty sure she did.
after this incident, on October 26, 2018, at Frida's house, is it your testimony that your daughter went upstairs with Mr. Dennings?
She did, they did go upstairs.
They went upstairs. And do you know about what time you got to Broward County?
I probably got to Broward, maybe, I can't really remember the time, maybe, I don't know, I don't know, but 1 o'clock was.
People, don't know spoilers. Don't tell us to hold our butts. Don't tell us to wait. Don't tell us to watch what's happening.
Yes.
Please, just let us unfold
I don't
here.
remember which restaurant.
We'll
Do
see
you
it
remember
as
who
it
you
happens.
went?
My daughter and, AA,
And that's James Francois' wife.
yes,
And do you remember, your testimony to the jury that you remember the defendant, how he was dressed without blood on his clothing?
I don't remember what he had, exactly what he had on, but I just remember that there was no blood, because I would have been, that would have freaked me out, so I know he didn't have any blood on.
No blood on him. Is it your testimony to this jury in terms of that you went to Frito Bang or Frederick Gibbons' house?
Yes,
Is it your testimony to the jury that there were other individuals present at that house?
yes,
Who was it?
I don't know,
Do you recognize any of the individuals?
no, I don't,
Okay. Your daughter, she was present?
yes, she was.
And in terms of your appearance here today,
Yes.
you don't want to be here.
Yeah, you made it on here.
I did.
Yes, you
So,
did.
and in terms of you were served with a subpoena and
Never
prior,
served, you never served.
and so you were ordered by the court to show up.
You never served me originally. That was a lie.
And in terms of your job,
Yes,
did you quit your job?
I got fired because you put me in jail.
And prior to that,
Yes,
before you were put in jail, did you quit your job?
No.
Okay, so you never quit your job.
I had to leave because you told my lawyer to put a warrant out for me. So I had to leave my job.
Okay, so you left your job.
Yes.
Did the defendant ever offer to pay for you and your daughter?
No, I left my home with it.
Have you ever made a statement contrary to that?
I don't remember.
If I may approach you?
Not an objection.
Yeah.
So,
Sure.
This is very close to what he told her not to do. Oh, I think it's making the state look really bad.
Are you done with that?
All right, more time in front of the judge. There. Ooh, we got a message while it's buffering. Why is it buffering? It wasn't buffering before. Now it's, oh, there we go. That's what I like to see. But in the meantime, while that's doing, Jeff leaning on the defense side. No, I just, like I said, I don't care. I have no monkeys in this particular circus here. Got no ponies in this rodeo. I got nothing. I just want the jury to arrive at a proper decision based upon the evidence presented. That's all I want. If the state proves their argument beyond a reasonable doubt, they should win. If they don't, the defense should win. That's it. But I think the defense is asking the better questions. The defense are making the better arguments. They're conducting their cross-examination better than the prosecution is presenting their direct evidence. The prosecution is wasting time. They're boring the jurors with an hour testimony from a guy who testified for an hour that he picked up pieces of glass, testifying for nearly 3 hours about how a gun works. And then ultimately coming down to going, we don't know which gun was used in this. Having a ballistics expert talk about all the shell casings, all of the, the ways, and not being able to say what gun they came from. And then having another witness come on and testify about how guns work, ballistics, and glass, and reach the same conclusions. And all the defense had to do was walk up and go, so you walked into this knowing nothing, and when you completed your inspection and your report, you walked away knowing nothing. And just cuts the prosecution out from underneath the knee, right at their knees, just takes their legs out from under them. So I think the defense is being way more effective in this case. And had that statement that those two statements we just read been allowed in, that would be a big thing. So if they can get those statements in somehow about, they told me they'd take care of me, they quit my job, they lied to me, I'm not getting any money from them, so now I'm going to go be bitch snitch. If those statements can come in somehow, that would be a huge shift in the favor of the prosecution. No, I don't think the judge sounds wishy-washy at all. I think this is a very good judge. Jim Satala says it kind of seems like the state is trying to do whatever it has to do to get her prior statements in, almost like it's what they base their entire case on, which doesn't bode well for them. Exactly. Yeah, they're trying anything they can to get these statements in. And is he just freaking singing to himself? He's rapping to himself. The jury is sitting here watching this putz rap. His handler, is she there? Where the hell is his handler? Did she go to the bathroom? Someone should slap him upside his stupid head and go, sit the fuck still. Yeah, okay, handler was lurking somewhere. I will say that again. Someone needs to tell him to knock this shit off. He is absolutely not helping himself by laughing and giggling and doing this thing he did the other day to the victims' families, sitting there rapping to himself. He's on trial for double first-degree murder. He's facing the death penalty, and he's just rapping quietly over there to himself. Tell him to sit the fuck still. Sit down, sit still, don't move, don't smile, don't laugh. Sit there and look freaking somber. Just do it. It's not helping the defense. And it's not helping himself. He's harming himself by acting like he doesn't give two shits about being charged with 2 counts of first-degree murder and facing the death penalty. It looks really bad for him. And this is the thing. This is the thing. Regardless of how well I think the defense lawyers are handling the situations, regardless of how well I think their cross-examinations are and their objections are, regardless of all of that, if the jury looks over and sees this guy acting like an idiot on the stand, they're going to go, this dick isn't taking this seriously. I don't like him. And they're going to be automatically prejudiced in favor of the prosecution because they just don't like this kid because he's being a dick and he's not taking it seriously.
Would take care of you and pay for your bills. Have you ever made a statement that is different than that?
Let's say anything like that.
Can you approach that?
Sure.
See, they're going down there. Ooh, she's walking right on the edge. Oof. She kind of got her to say she doesn't lie to the police, so the police report the prosecutor is going to come back and argue, okay, she testified she doesn't lie to the police. She testified that she wouldn't have any reason to give a false statement. So therefore she's saying whatever she told the police is true. So we should let that in. And now she's doing this. Have you ever told anybody you're going to do this? Have you ever told anybody you're getting money? Have you told people you're getting paid? Did you do it? And then now she's like, I don't remember. Now she's coming up to show her something to try to recollect, to cause her to recall the events or whatever. This is walking very close to the line that the judge very specifically told them to stay away from. Strawberry's on the floor behind me, and Yoda's probably on the sofa.
Okay,
Yes, give me money for my bills.
so Ms. Holmes, is it your statement testimony that you never stated the promises that were made to us by YNW
Whoa!
for me to quit my job
Wait!
and they would take care of us
What?
for all lives? They didn't want us talking with prosecutors, but now they've all disappeared. That you never said that before.
I don't remember saying anything.
Objection, Your Honor.
Whoa.
Thank you. Why don't you go sidebar?
Holy shit. Wait a minute. Wait. I'm sorry I had to go back here and that's got to buffer through this.
Disappeared. That you never said that before.
I don't remember saying anything.
Objection, Your Honor. Move for mistrial.
He just made a motion for a mistrial. Wow. I'm a little bit shocked right now. I'm a little bit okay. If you have stunned the law rack speechless, congratulations to you. The judge very specifically told her that this was not admissible for two reasons. And she just rolled straight over it. Now she's going to argue she's satisfied those two rules, so therefore she should be able to get it in. But wow, that's a I'm literally speechless. Now, if I was the prosecution, I would have called a sidebar and or asked the jury to step out for a bit and then said, I think I have satisfied both of these conditions and I would now like to enter this into evidence. And heard and gotten the go ahead to do it before I do it. Not just walk up there with dick swinging and start slinging, you know. Hey, I made a little rap of my own, didn't I? I didn't even mean to do that. Yeah. Ooh. This is mistrialable. If the judge says you did not meet the burden of proof or you did not meet the test for introducing this evidence and you did it anyway, evidence of this bombshell nature that she may have been paid in exchange for a promise to not cooperate with prosecutors. If they allowed if they just railroaded this in without meeting the requirements for this to be let in, that could easily be the grounds for a mistrial. Wow. Let's see what they argue. I'm sure they're going to go over the elements of the test again, the veracity and the prior statements things. So let's see how this plays out. There's an hour left. So, like we just heard, because she was told not to do it, she asked a few questions, and then she did it. She just went and stuck it. And I was screaming in my head at the defense lawyer why he was letting her this is a pivot point. No matter what happens, this is a pivot point in this trial. This instant, this is a pivot point. Because she's stuck this. If she's wrong, this could be grounds for a mistrial. And then we have to look at, I looked at the defense statement, the defense's actions twice through two different filters. One, in my head, I was screaming, why are you letting her finish this question? Object, object, object. But if he objects during her question, it would clearly get shut down. It would go up to a sidebar, and we would argue with the judge for a while, and then he would decide what to do. And the trial would continue. But he sat there calmly, knowing she was going to do this. He saw where this was going. I saw this was where it was going. That's why I'm saying she's walking really close to this line, and every question she's asking. He sat there calmly and let her finish that entire thing. So the jury heard it. He wanted the jury to hear that. So he could utter those lines, objection, move for a mistrial. So, if it's in, this could be the doomsday piece of evidence for the prosecution. This could be a nuclear bomb for the prosecution. If the judge doesn't think she met this burden of the requirements, the test to bring this evidence in, he could easily declare a mistrial. And if the prosecution had just let it go by and objected instantly when she started walking down this case, trial would have proceeded. This is going to be a pivotal point here in the trial. Whatever happens in the next hour is going to be a pivot point.
Thank you.
Listen to the prosecutor read this statement, and then the defense says, objection, move for a mistrial.
Talking with prosecutors, but now they've all disappeared. You never said that before.
I don't remember saying anything.
Objection, Your Honor. Move for mistrial.
There you go. Lex Luthor says, how many mistrials equal not guilty for the defendant? Well, if there's a mistrial, they'd say, we're done. It's a mulligan do-over. You get a do-over, basically, for and the prosecution can decide to prosecute again, or they can just drop it. And if they essentially, there is really, as far as I understand Florida from working with other trials and whatnot, there's basically no end to the mistrial. I mean, if you have a mistrial, you can do it again. But again, not being a Florida lawyer, whatnot, I can't say definitively, but I seem to recall that if the mistrial was caused by an intentional act by the prosecution, it could be a mistrial with prejudice, meaning you cannot bring it back to trial. So if it can be that is just I'm not sure. We need a Florida lawyer to help us out with that. But if the mistrial is due to an intentional action by the prosecution, in other words, if the prosecution intends to cause a mistrial, if they do something that they know would cause a mistrial because they think they're going to lose their case or whatnot, then it's lost. But I don't think that would be the case here. She just did something the judge told her not to do. I don't think she wants to get a mistrial. Let's see where this goes.
Thank you. Why don't you go sidebar?
All right, let's. Dang it. Sunday morning in Korea. Everybody's using their internet apparently. Let's go buffering Buffy McGee. All right. Let's see what happens now.
Ladies and gentlemen, there was an objection made to the last question. I made a determination that was an inappropriate, improper question. And the way it was phrased was totally improper. And therefore, I sustain the objection. I am instructing you that you are to disregard the question. All right? I'm going to ask counsel to rephrase the question. Go ahead.
Don't like that. It's the old, don't hear what you just heard. Please unhear this. Unring the bell. That I'm going to ask her to ask this question in a different way. How do you ask that question in a different way?
So it's clear. Ms. Holmes, did the defendant ever make you a promise to quit your job and that they had us?
Objection. Asked and answered.
Thank you. Overruled. Proceed.
I don't remember saying anything like that.
So your testimony is that you've never said that.
Objection. I don't
Objection.
remember.
Excuse me, counsel. She answered the question. All right? Let's move on.
So with regards to your statements with Portland Henry. Do you remember speaking and talking about your daughter with Portland Henry?
No, I don't. When was that? I don't remember.
Sure. When was that? Here, I'll give it to you again. This was February 5th of 2021. Did you send that to you?
Oh, no, I don't remember that.
You don't remember that?
Yeah.
Did you talk to Portland Henry about your daughter's involvement in this case?
Not that I can recall.
Ms. Holmes? Did your daughter tell you what happened in this case?
Objection.
No.
What's the objection?
Calls for hearsay. It's immaterial.
Not what the statement said. Did you say something about the case? Overruled.
No,
Not
she
what
never
was
told me
said.
about it.
Just,
She
did
never
you have
told
a
me about
excuse me. Not what was said. Was there a conversation?
Was there a conversation that your daughter told you what happened in this case?
What do you mean what happened?
Did your daughter ever
She never
tell?
told me. I asked my daughter, did she know anything about this case? And she said no.
Have you ever made a statement different than that?
Not that I can recall. No, I don't remember saying anything like that.
May I approach her?
Yes, ma'am.
We object.
Why don't you show it to counsel first?
Can we approach?
Yes.
Sorry.
Oh my. I don't think we've got some buffer built up here yet, so we'll see. Oh, we do a little bit. All right. Okay, the jury's leaving. Are we talking about anything important or just taking a break? Great. Now you get a buffer. All right. Yeah, they're just waiting.
Jury entering.
Ladies and gentlemen, thank you. Let the record reflect the presence of the defendant, his counsel, the assistant state attorneys, ladies and gentlemen of the jury, all witness remains on the stand. Please be seated. And remind you, Ms. Holmes is still on the road. Counsel, please continue.
Only about this one, I can ask you, did your daughter tell you, did you have a conversation with your daughter about what happened on October 26th of 2018?
Yes, I asked her if she knew anything about that.
Did she tell you what happened without, no, she
She
did
just
not.
told she didn't know.
Have you ever made a statement that is different than that?
Your Honor, we'd object to lack of foundation, calls for hearsay, speculation, unless they can establish that that witness was present.
Thank you. The objection noted. That's what I previously ruled on sidebar. Proceed. To your approach.
Showing me your messages from Instagram from February 5th, 2021.
Who was that Instagram? Is that the one, this Henry stands with Portland?
Ma'am,
I
sorry.
don't remember that Instagram.
Look at it.
I already looked at it, you already showed it to me.
So is the.
I don't remember that, you showed it to me like 3 times already.
So you don't recall making
I
a
don't recall
statement
making a
from.
statement. No.
Excuse me, one at a
She's
time.
arguing,
Please
come on.
Let her finish her answer before you ask the next question.
So you don't recall making that statement?
No, I don't.
Let's go. Brandon says dogs are
So
not.
you don't recall saying,
We're like $18 away from shop game.
Sustained.
so.
TR
Ms.
Greater X,
Holmes
this is going well for the
said
defense.
that
Maya, why would you motion
daughter
for a
didn't
mistrial
tell
when you all you have to do is
Objection,
over
asked and
again?
answered.
Sustained.
so did you ever make a
Possibly
statement
with
different than that?
Objection, asked and answered.
Sustained.
Into the statements that with regards to October 26th of 2018. Is it your testimony to the jury that you remember coming to Fort Lauderdale?
Objection, asked and answered.
Sustained.
Oh, the
Listen, I
judge
just
is
want one of you to make an objection. So whoever's going to handle it.
Yes.
All right.
I apologize.
Ms. Holmes, is it your testimony you don't remember why you came down?
I told you why I came down.
Okay, why is that?
Objection, asked and answered.
Sustained.
Ms. Holmes, have you ever,
Let's go, Elaine. Ask a question. Let's go, Ms.
let
Bretterhoff.
me rephrase.
Yeah, have you? Let me rephrase.
Ms. Holmes, did your daughter ever threaten
Oh, come
to
on.
cooperate with law enforcement?
Objection.
Sustained.
Yeah.
Ms. Holmes, did you threaten to cooperate with law enforcement?
Objection, asked and answered.
Different question.
Why don't you come sidebar? I want you to question, please.
Okay. Judge is getting hot. Yeah, judge is getting upset. This not only is this bad for the prosecution, but it looks very, very bad for the prosecution. Every question they ask is getting shot down by the judge. And I like how the objection is being made. I think the tone of the defense lawyer's voice is very important. MG Law, see you there. I'll send you a link here in just a second. I think the tone of voice this objection is being made, these objections are being made in is important. I mean, if he was just sitting there and she's asking these questions over and over again, and he's like, objection, asked and answered. Objection, asked and answered. Objection, asked and answered. I think that kind of makes the jury not like the defense lawyer because he's just interrupting the proceedings. But with that indignant tone of voice, I think it makes the prosecution look bad, which it should, because they should be asking the questions. But it makes the defense not look like they're interrupting. It makes it look like the prosecution's wasting time and or trying to do things. He's like, objection, it's been asked and answered. Objection, asked and answered. Like, how many fucking times is she going to ask this question? Let's move it along. And I think it makes people look a little bit unfavorably towards the prosecution. And T, where'd we go? T greater X, where'd you go? TR greater X. I'm finding you here. Hang on just a quick second. That was like 2 minutes ago. There we are. For the doggos. Well, that puts us over the release the doggo cam and affix the law and cut cage threshold. So there's only one thing we can do.
Release the hounds.
We get strawberry cam today. There we go. Boop. We're all dogged up. All right, there we go. Thank you so much for that, T Greater X. That's super. Thanks. Huh. All right. Well, here we go. Yep, they're going to argue.
When you came down to Fort Lauderdale, was your daughter concerned?
All right. Let's see how many more questions get objected to before he kicks the jury out again and starts yelling at people. I think it's going to happen soon. This is a highly objected line of questioning. So, all righty, let's kick it in and see what happens. I got thoughts, but I'll hold them.
So, Ms. Holmes, I want to ask, were you present when your daughter spoke with law enforcement?
She was 17, I had been present.
Do you recall about when that happened?
If she was 17, that had to happen in 2018.
Okay. Without getting into what she said on that. Do you remember where that statement was taken?
No.
Whoa, volume, people. Jeebus.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Dennis?
Objection. Cause for conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
I like how he ordinarily people, the lawyers will stand to give their objections and then they'll sit back down. He's not even sitting back down because he knows the objections are coming in. And speaking of objectionable people, it's MG Law. What's up,
sidebar.
sir?
Can we approach
Yeah.
sidebar? Yeah, I came in after getting the kids to bed. I was like 45 minutes behind, and probably 3/4 of that was spent watching sidebars. This is ridiculous.
Yeah. Did you get to the mistrial section yet?
Yes, yeah, I've caught up
Okay.
to live.
All right.
Yeah.
Comments?
As a judge, I would have warned the state to move it along and stop pushing this line, or I would end their line of question. I would end direct examination.
Would you have given a mistrial?
I think it's warranted. I think there would be sufficient grounds for it. He's warned the state so many times not to ask these questions, and they blatantly asked the questions. He said, "Do not do this," and they did it. I would have threatened her with a mistrial with prejudice because you are directly disobeying my order to you, and see whether they take it seriously or not.
I mean, that was a bold. Because I said that,
Yeah.
as I said, I think this is a seminal moment in this trial.
Mm-hmm.
Whether you basically let her say that the witness was paid to not cooperate, and he didn't get cooperate, so now she's going to turn, quote, bitch snitch or snitch bitch or whatever. Bitch snitch, I think is what it was. So yeah, she got paid to lie and not cooperate. Now she's pissed because she didn't get the money she was paid to shut up.
Yep.
And I thought it was a ballsy move for the defendant to sit there and let them get that entire question out rather than jump on it instantly.
Yeah, that's tough to do, to know that the objection is going to be sustained, that they've clearly crossed the line, and to sit there patiently and let the question be asked completely before. It's hard to do that.
Now, again, as I mentioned, I'm not a Florida lawyer, but we talked about the mistrial. You can declare a mistrial with prejudice. I mean, you cannot refile the case. Mm-hmm. The charges are just dismissed. Or you can bring. Normally, mistrials are excluded from double jeopardy, but as I was saying, in some places, maybe most places, I don't know, particularly Florida, but if the prosecution does something that intentionally causes the mistrial, it's off the grounds. I think this is kind of on the line. I don't know if this would be an intentional act or her just rolling the dice and hoping for the best. I don't think she's trying to cause a mistrial.
And they may take it up on appeal. They could take the with prejudice up on appeal and say, no, we established the proper grounds to get this in, and see what the appellate court says. But I think the judge would be well within his rights to have mistrialed it, declared mistrial with prejudice. I mean, he told them, this does not meet the standard. Do not do this. Do not ask the question. Do not testify through your questions. And then she turned around and did exactly that.
And
it's.
I mean, I think it's definitely. I mean, I think it's stupid that she didn't. She didn't go for a sidebar and just say, "Look, I think I've met this. Can I bring this in? This is going to be my next question. Do you have an objection to it, counsel? Because I'm going to ask this question next." And let the judge decide.
And the judge could preemptively say yes or no. And
I think it was stupid of her not to do that.
Well,
and as I was just saying, I do like how he's making these asked and answered objections in the tone of voice. It's like, bitch, please. How many times are you going to waste all of our time with this question and not just doing the normal objection? I think it just makes just the intonation of his voice says, this prosecutor is wasting your time. She doesn't know what she's doing, and she's just being bothersome. Blame her, not us.
And it comes across as she's not listening to the witness.
Yeah.
I mean, she's asked a question. The witness has answered. Didn't give the answer you want, but she answered the question.
All right. Well, with that, let's get in here and see how the last 40 minutes of this plays out. I'm guessing 35 minutes of it are going to be either sidebars or out of the presence of the jury things, because I think he's right on the edge of getting rid of the jury again. So we'll just have to see. But I'm gonna push play, and then I'm gonna go grab some more ice for my next Dr. Pepper. I'll be right back.
When you arrived in Fort Lauderdale and saw Mr. Simmons, did you ask him what happened?
Objections. Asked and answered.
I'm sorry, repeat the question.
When you arrived in Fort Lauderdale Did you ask Mr. Devens what had happened?
No, I did not.
Nothing further.
I have one
Finally,
question.
jeez.
Yes, sir.
You came here and one of your first, let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, Counsel, you direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I did.
Who do you feel threatened
Ooh,
by?
cross-examination.
There we go. Yeah, fireworks.
In the prosecutor's office.
This prosecutor.
Yeah.
Yes, I did.
Thank you.
Holy shit, that was cross-examination?
Yes, sir.
Oh,
God, good thing I didn't miss cross-examination.
oh, that was great.
Holy shit. Wow.
I kind of thought her attorney was going to do that when he came in, for
Yeah.
basically threatening perjury charges against her.
Yeah, he was rather unimpassioned. I thought he was going to go off on the prosecutor, but holy crap.
Yeah,
I
the defense
blinked
counsel's
that.
been great so far. They've been really good.
That was brutal and to the point. Wow. Again, I'm a little bit speechless by that. I was speechless by her stupid comment and the motion for a mistrial, but do you feel threatened? Wow. Let's watch
We gotta
the
replay
entire
it.
cross-examination again. All right, let's watch the entire cross-examination play out one more time here. Holy shoot. Okay, I'll just shut up and play. That's just like wild. Yeah, what's up, Strobs? It's taking a long time to collect her notes and get down there too.
When you came down to Fort Lauderdale, was your daughter concerned for Mr. Devens?
Objection. Cause for conclusion on part of this witness.
Based on your daughter's demeanor, how was she acting?
Sustained.
So
Yeah,
speculation.
this is where I left.
When you arrived in Fort Lauderdale and saw Mr. Devens, did you ask him what happened?
Objection. Asked and answered.
Overruled.
I'm sorry, repeat the question?
When you arrived in Fort Lauderdale, did you ask Mr. Devens what had happened?
No, I did not.
Nothing further.
I have one question.
Yes, sir.
I have one
You
question.
came here and one of your first, let me get it.
Objection, Your Honor, improper.
I haven't asked you.
Excuse me, Counsel, you direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first,
She objected to the question being
Before-
improper before the question
Yeah.
was asked?
Yeah, you missed that part. He had not even asked a question yet, and she's like,
What the hell was that?
Yeah.
Oh, and I got to buffer again because what the hell is that? How do you object to the properness of a question before it's even asked? That just makes you look stupid. And
she
I love
knows.
that
She knows he's gonna nail her.
well, I love that he told her that she's dumb because the question hasn't been asked, and the judge says, "No, talk to me." She said, "Yeah, she's dumb because the question hadn't been asked." He got to say it twice. That was
In
good.
front of the jury too.
Wow. All right.
You direct your comments to.
I'm sorry, I haven't asked anything yet.
Ask your question.
When you first took the stand, you said, "I feel threatened."
Yes, sir, I did.
Who do you feel threatened by?
Objection, Your Honor.
Overruled.
Christine Brown, in the prosecutor's office.
This prosecutor.
Yes, I did.
Thank you.
Anything else in this witness?
Yes, sir.
I got a few things to say.
Ms. Holmes?
Yeah.
You said you feel threatened by
Of
me.
course.
Okay. Did you fail to appear for numerous court appearances?
No, I never served me, lied,
Okay.
lied to the court.
And with regards to, did you work in Reading, California?
Yes, I did.
Okay.
Material.
Overruled.
And so that was a location you were at.
That's why I was traveling, so yes.
Okay. And in terms of the prosecution, you have been served on various occasions to testify.
You served me a subpoena on November to be the next weekend. I was in California, 10 hours away. It wasn't even served correctly.
And prior to that, you were served with a subpoena in
Never.
February of 2019.
You never served me. I know you served me to a location I didn't live at anymore.
Do you recall coming to the courthouse in February of 2019
Objection beyond the scope.
Anything about the courthouse.
Will be.
I'm sorry, Mark.
Yeah.
Wow.
This prosecutor is flailing.
Yeah. No words. It's just.
Yeah, you're out of your depth, Donnie. All right. She just looks so defeated.
You even went so far as to hire an attorney
Yes, I
to try
did.
not to show up.
I sure
Oh,
did.
so?
And has the state offered you any money?
The state basically has me on a monitor. I have to go to my job with this. It's embarrassing. People think I'm a criminal. The state has run my life.
And
Oh,
in terms
God.
of your feelings and ill will,
Oh God!
Um,
The state has has an ankle monitor on her to make sure she comes to court.
Yeah.
What the hell is that?
She's
never
asking
heard of
questions she doesn't know the answer to.
Wait, I've never heard of that. Tethering the witness
Yeah.
to make sure she shows up.
I guess what they're saying is they've kind of implied that she's kind of not appeared under subpoena a couple of times.
that
So-
seems to be what they're implying. Yeah. So wow.
But
And then like everybody thinks I'm a criminal and the state is ruining my life. I hope this is a jury that, well, I shouldn't say I hope. It'll be interesting if this is a jury who doesn't take the state's power in a good way. If this is a jury of people that don't like the state and think the state has too much power, they're saying they're tethering me and they're ruining my life.
yes, this is exhibit
not what
A
you-
right here.
Yeah, that's not how you want the jury to be thinking about the prosecution. Wow. Oh my.
will towards the state and myself.
I just feel like you lock up innocent people.
And does that influence your testimony today?
It's not influencing my testimony.
Have
No,
you-
I'm telling
have
you,
you- that's not-
I don't
that's
understand.
not responsible.
Excuse me, hold on.
One at a
Only
time.
one of you can talk at a time. You ask the question, counsel, you answer it, and when you let her finish her question, and then when she starts answering the question, you let the witness answer her question, all right?
Yes, all right. So my question was non-responsive on that one.
Ask your question.
So, Ms. Holmes, in terms of the court order that was issued, you're aware that that was found to be valid?
No, I'm not aware of that at all.
Okay, you hired an attorney to go and represent you at the Fourth District Court of Appeals,
He had to hire an attorney because he tried to get him this far.
and that's a false statement.
Objection.
Excuse me, counsel, you're not testifying. all
I
right?
agree
You
on
ask-
that.
What
excuse
the-
me,
what
you
the hell?
ask the
She-
question, all right? That's it. You
Oh
ask
my
the
God.
question.
Please don't
You
buffer.
ask-
Damn it.
Oh dear Lord.
I want to hear that again.
Yeah, she testified. Oh, that's a false statement. I mean,
Yeah. This is
ridiculous.
I'm sorry. I'm not going to go back and forth anymore because right now is the peak part of the day where every single child in Korea is playing an online
playing a video
game.
game, yeah.
Because it's a beautiful sunny summer Sunday morning. Why would people be outside? This is like literally the
Yeah,
peak
you-
internet usage
yeah.
for Korea. Sorry about this.
Yeah, I had another news stream going. We got bad weather here in the state tonight, but
Court of Appeals?
it's not here yet.
Here. Is she tanking on purpose? No, I think she's just
No.
struggling and flailing and
She's flustered.
yeah, and she's going Elaine Brederhoff here and just saying the first thing that comes to her head, regardless of how stupid it is.
And hired an attorney because he tried to get him this far.
And that's a false statement.
Objection.
Excuse me, counsel, you're not testifying.
I
all right?
agree on
You
that.
excuse me, you ask a question, all right? That's it, you ask the question.
And so.
Now she gets yelled at in front of by the judge in front of the jury.
Yes,
And you then try to get any sort of court order requiring you to be here in court thrown out?
No, what I did was I hired an attorney because you were saying you served me a subpoena that you never served.
And that was found to be valid.
You never served me a subpoena that was never, you never served me.
Oh.
I've never seen a subpoena from you from those addresses that you said you served. Those
So-
are not my addresses.
Your testimony is that you have never been served to appear in court.
Objection,
I've
asked
served-
and
I've
answered.
never-
Sustained,
Yes.
excuse me, sustained.
And so with regards to your feeling threatened on them, have I ever, any sort of physical violence against you?
No,
Do you have any written threats from me?
it's intimidating, you've intimidated me this whole time.
And-
Oh, God.
And in terms of your participation in this case?
Yes.
you
Notice how she
understand that
didn't
you
say
were served a
ever
subpoena to
threatened
appear
you
today?
orally.
You served a subpoena after you arrested me. You
And
served
you,
a subpoena at the jail when I was in Broward County.
and you understand you're pursuant to that order?
I'm here.
And that requires, under the law, to comply with court orders to, and that compel the attendance of witnesses.
I've been complying.
Nothing further.
Anything further?
No, sir.
Thank you. Is witness excused?
Yes, Your Honor.
Thank you, ma'am. You may step down, you're excused. Want to sidebar here, please?
Oh, sidebar. Wow.
That's kind of brutal. A couple Ginger's
Understatement.
333 has a couple of comments. If she would just cooperate with the state, wouldn't have. If she would just cooperate, then the state wouldn't have to take these measures. Read that again, King Ginger. Read what you wrote and tell me if you see the problem in what you just wrote. If she would just cooperate, then the state wouldn't have. She is saying I was never legally served with these documents.
Mm-hmm.
The fact that
She's
she
saying
heard about
they served her at an address that she didn't live at.
I'm hearing about a. Are we starting talking again yet?
Don't discuss the case, don't form any opinion about the case. Don't
Dismissing the jury.
allow anyone to discuss the case in your presence.
Oh, I guess this is the end of the day, so
Same
we'll address
avenues
it.
we Give you every time we break. We're counting on you to follow it. All right, just leave your notepad on your chair. We'll see you back on Tuesday, 9 a.m. Thank you.
Tuesday. Oh, it's that
Yeah.
new holiday in America.
Yeah.
Now I got to think of something to do for Maritime Monday. Shit.
I got to work. I have to work Monday. We don't get that day off.
Well, we certainly don't get it in Korea.
When I work for the SBA, we got that day off. But
For
Oh,
the state.
we're still got a couple arguments. Cool. All right.
Let the record reflect the jury stepped down. Counsel remained along with the defendant and the assistant state attorney. Ms. Bradley, my clerk is advising me that
I love his little sign right here.
Evidence that she had was something that might have been marked as an exhibit.
Professionalism
It
and
was not
civility.
our
Anything less will
copy
not be
of the
tolerated.
So
transcript.
you're okay with it?
Yes, Your Honor, I printed copies.
All right. In any event, so
Oh,
jury's been excused, counsel remain along with the defense, so you have a couple motions from this trial. You want to talk about those?
Yes,
All
sir.
right.
always you can talk about the mistrial, but we had Lincoln Kane stop by and drop an Aussie a
Oh.
hundy. Lincoln Kane,
Good
my
day.
brother. Hey, yo, Jeff, feel free to stop by later after your stream. Cheers. Well, I guess I'll be showing up on Lincoln Kane for a little bit after here. That'll be
Nice.
certainly a palate cleanser from this. And if you don't know who Lincoln Kane is, just go to Lincoln Kane. Throw up a link there in chat if anybody wants to go over to Lincoln Kane after. Feel free. I'll probably pop in there for a little bit, say thanks and all that other stuff. But all right, let's hear what the motions for the mistrial are. But I guess before we do that, I want to address these King Ginger things here. If you know that they expect you to show up someplace, even if you know the date, time, room number, and everything, if you aren't served legally, you don't have to show up. If I call MG Law and say, by the way, you're supposed to come here and testify in court tomorrow morning at 7 p.m., he doesn't have to show up.
No. Not without
If
a
I send
subpoena.
him that in writing to a place he
Yeah.
doesn't live anymore, or give it to somebody that doesn't have authority to accept service, she doesn't have to show up.
No, I think the subpoena was one of them was found to be valid. Probably the one that has caused her to be there at the trial.
Yep.
She was talking about at least one or two previous subpoenas, but we don't know whether those were valid or not.
And
But-
you're saying cooperate with the state who is not legally serving you documents. If you would just do what the state tells you to do, even though it is unlawful and they didn't do it properly, just cooperate and you won't have problems. That's a problem. Yeah, we don't do that.
And then, the state saw, well, then you got, she's like, I had to hire an attorney. Well, of course, she almost kind of demeaned her for having to get an attorney. Well, why wouldn't you have an attorney?
Yeah. Well, do you seriously believe her? Yes, I believe her, because if they had been validly served, the prosecutor would have jumped down her throat and said, it was validly served on this date. Here is the statement from the process server who served it to show you that it was validly served. The fact that they didn't prove that it was validly served tells me they knew it wasn't.
Yeah, you would have an affidavit of proof of service from the process server or the sheriff, whoever served it would have a return of service. So,
yeah. And the other statement from King Ginger was intimidating her. How though?
Well, she implied she was committing perjury.
Yeah, when she's giving her testimony and the prosecutor, the prosecution, the people who can charge you with crimes imply you're not testifying the way we want you to testify. You better go talk to your lawyer. If you want to keep saying this, go talk to your lawyer, parentheses, because if you don't, we could come after you and charge you with perjury. Please testify the way we want you to.
Yeah.
That's intimidation. And again, I think she said, did I threaten you physically? Did I threaten you in writing or intimidate you? Did I intimidate you physically? Did I intimidate you in writing? No. She didn't say, did I intimidate you by anything I said to you? She didn't say that.
Yeah.
So, all right, let's hear what these arguments are.
As sure as I could predict that Tuesday comes after Monday, I made sure to stay up till 2:00 last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible.
Yep.
Instead of at least admitting that was what the state intended to do it.
Yeah, he
advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to plan one, the original one all along,
which is just to throw it in.
The state reading evidence from written documents and out-of-court statements, including police reports, statements on Instagram, arguments being had into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially trying to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the.
Wait, people are saying I missed an important question because I skipped forward.
I don't know.
What important question? And if there was an answer, what was the answer? Someone quickly throw it up here in chat so we can go. What was the important question and what was the answer? And who asked?
I made sure not to watch any coverage, any other streams on this yesterday at work, or Thursday afternoon because I was waiting to watch it here. So,
yeah, so why do they have an ankle bracelet on her to make sure she shows up to testify
but
this
yeah,
time?
he argued before they ever brought her on as a witness that this is exactly what the state was going to do. It is improper, and judge let it in, and all hell broke loose.
She asked the witness if the defense had paid her. I think that was a misstatement. She meant the defendant, or the defendant's management company or production company or whatever, because that was the original line of question, was that YNW as a company had paid her expenses. I think that was just a misspeak.
Okay. Yeah, I think I heard. Yeah, Jim saying it was right around the mistrial.
Yeah. Okay.
Yeah, I think I heard that one.
Yeah, if she did say defense, she clearly meant defendant or the defendant's company, because that was what the whole argument was about at the beginning. That was sort of like in the Zachariah Anderson trial when idiot dumbass Gravely said that they found the body. That was just a total brain fart misspeak. And it's when you misspeak like that, you just don't even draw attention to it, because it's just, the more it's like, don't look over there, because then it just draws unnecessary.
They're saying maybe later on, when we skipped ahead at some point, that they're saying that she said defense team in her question. Did the defense team?
Well,
I don't know. I was live at that point. So,
but first of all, the defense team is not going to do that.
No.
Especially not if you're at this level of defense team. You're not going to risk your law license and prison time to do this. It's just whatever it was. I say it was a misspeak. Some people are even saying defense. All right, let's just go on with whatever.
Back door, which can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions, with the implications that were being all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason, we think that it was deliberate.
Mm-hmm.
It is highly prejudicial. This jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that means.
This is your motion for mistrial, Mr. Addison?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, it's second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness.
Oh, Jesus.
Oh, okay.
Maybe. I hope she stands right up and said, "Oh, I'm sorry, I misspoke." I hope that's what she does.
Wow.
I think I kind of got to take back my I'm sure it was a misstatement comment back. I think I got to take that back. She's not that stupid. The text she was trying to get in specifically said YNW. And it was like the manager, I can't remember what the wording of the text was exactly, but it was like a production team or management team or somebody else. That would be a really stupid thing for a prosecutor to say, unless she could come in with legitimate, like actual receipts. What?
Wow.
I don't know what the hell's going on here, but let's. I mean, can you imagine a defense team even doing that? Like, can you-
Yeah, that. I can't
I mean,
imagine
it-
anybody doing that. But
it's
I mean, she's not an expert
absurd.
witness. If she was an expert witness, that's one thing. But paying a witness, but the implication. I mean,
Well, it was you. They promised to give us money, and they didn't give us the money, so now we're gonna go. This is weird. All right, let's find out what happens. Like if and apparently, I mean, according, I doubt she's gonna stand up, but I would just stand up and go, "Holy shit! Did I say that? Oh, I'm so sorry."
And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table.
Yep.
And despite the judge, your honor's instruction to ignore it, it's pretty hard to ignore something like that.
I would be
When their
very
entire
inclined to
questioning
give
for
the
the
mistrial.
last 30, 40 minutes have been so improper, and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text, couldn't distinguish her from a can of paint until she showed up at the depot, and I haven't spoken to her since, so just to let the court know there is no factual predicate for the implication,
Couldn't
or not
distinguish her from a
implication,
can
the
of paint.
accusation
I've never
made by
heard
the
that.
state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
It speaks.
Wow.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. Defense read into it and implied it meant it was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not presented in any way.
Oh, he's ready to jump.
I'm
Yeah.
basing it on based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's very, in terms of the forming.
Can't wait for her to stop talking.
It was understood that I was put under very strict and difficult conditions to formulate any question, because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state
They're not
would be
admissible.
seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible.
Doesn't matter what you say.
And the status of this impression that there is a catch-all, we're only trying to seek justice and do good, exception to all the rules of evidence, and there is no such thing. If it's admissible, admit it through an admissible procedure.
Exactly.
You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or that Mr. Demon's interests have been irreparably prejudiced before this jury.
Thank you. In any event, I'm going to defer ruling, take it under advisement. We'll see everybody back on Tuesday. I suggest that you talk with your client, discuss with Mr. Demons whether or not his feelings about the motion for mistrial. I think it would be appropriate that he be consulted as well. But I haven't reached a conclusion about it, and so I'm gonna see exactly what was said. I thought I heard what was said, and
Yeah.
I'll check with the court reporter, get a little piece of that transcript, and
Mhm.
we'll go from there. And I'll take it under advisement. But you talk to your client about it. We'll see everybody back on Tuesday. All right.
Yes, sir. Have a good weekend, sir.
Judge,
Yeah.
since we're breaking early today, can we have a few minutes with our client? right now?
Sure, I'd like you to take a few minutes with him. I'd like you to talk it over with him.
Yeah.
Yes, sir.
Can we have the cameras off?
Make sure it's really what he wants to
Can't
do.
hear you.
The camera's off.
Oh, you want privacy, that's fine. Right.
Mhm.
Cameras can be skewed. They can go out
Yeah,
of court.
damn right. I want privacy.
Of course you want privacy.
Everybody can go out of court. All right?
Thank you.
Adjourn. This is like a private conference area.
Thank you.
Oh,
America.
oh, got that gold fringe.
No.
Wow. Yeah.
So we're gonna possibly have a mistrial on Tuesday.
Yeah, he almost sounds like he's considering it. He's going to take it under advisement, but he's make sure you talk to your client and make sure he really wants to do this, because I don't know that he's going to do it with prejudice like he should, because this was clearly misconduct and it would be warranted. So he's like, you tell your client he might be sitting in jail for another 2 years before the next trial comes up.
That's the point. He's been there 4.5 years already.
Now maybe the judge could, levy issue a bond, set a bond
Mhm.
at this point so he can be out.
The
pending
double
this.
first-degree murder, probably not.
Yeah, but I don't know.
The hell are?
But-
What are you rocking back there on the table? Is it like Korean wine? What the hell is
Yeah,
that?
soju.
It's like that's a big ass soju bottle.
Yeah,
Okay.
we got an Asian mart here in town. It's like $12.
We don't have soju bottles that big. There's like the regular bottles, and then there's like the gallon and 2-gallon.
Yeah,
jugs.
they have a bunch of the little like 12-ounce bottles,
Yeah.
but yeah,
Huh,
we saw it's a 750 here. So yeah,
we don't have 750 milli. It's like
it's awesome.
the regular one, and then the anyway. Sorry, got sidetracked by the. I thought it was like soju, but it's in a wine bottle. That was weird. All right,
Yeah.
whatever.
Yeah.
Yeah. So, sorry, back on track. ADHD lawyer strikes again. My gut feeling would be, if I was the judge right now, I would be inclined to grant a mistrial without prejudice. Because I think I don't think she intended to cause the mistrial. But
It's hard
I mean,
to-
it's very on the line. It's very. I just have to go with gut feeling. But
I mean, he
What about you?
specifically said, "Do not read these messages as part of your question to the witness." And she turned around and did exactly that. You can't. I mean, there's no way she didn't intend to do it, and she deliberately disobeyed. And he could hold her in contempt. I mean, that was direct
Yeah.
contempt.
so
I don't
would
see how it
you
was
grant the
acted.
mistrial?
Yeah, I probably would. I don't see how the jury can unhear what was said. Those
So
questions.
we both agree with that, and you would grant it with prejudice.
I probably would. You have to be hard. That type of behavior will never be corrected unless there's a serious consequence for it. And as we've seen with Gravely and now here, the state's going to push the line. They're going to do what they want because they know there's no consequence for it.
Just Jen says, so these are the technicalities that get people off, huh? Yep.
Yeah.
Exactly. That. But see, what
And this
some
isn't
people
really
call
a technicality.
technicalities, we call rules of law.
And you're prejudicing is a right to a fair trial. And when you're doing something this blatant, the jury sees it. The jury's hearing this question, what's being said, and they're gonna, it taints their judgment. They can't unhear that question. You can't unring that bell. And you may hope that they forget about it by the end of the next 10 days or whatever they've got left. Why the state needs that long to present their case, I don't know. But that's something that may stick with them the whole time.
Wow, because I think it's clear mistrial, and I think the judge I may be reading way too much into this, but I think the judge kind of maybe tipped his hand a little bit when he said, "Make sure your client wants
Yeah.
this mistrial."
Yeah. Make sure
I
he
think he
wants.
showed his hand a little bit.
Yeah.
But why wouldn't he want the mistrial?
Because you're going to sit, he likely is going to sit in jail for 1, 2, however many years it takes for them to bring this back around, find the time in the scheduling for this judge in this courtroom, and to, whenever their jury terms are, they likely don't, here a lot of times you only have jury terms every so often, not even, it's not every month, always, depending on the county. It may be spring and fall, or summer, winter. It may be every other month. Some the big counties here may have it every month. But you then have to fit in with all of the other trials that are scheduled now, and you may be bumped out a year or two, and you're then just sitting in jail.
And on the other side of this, the judge has to, especially with the prejudice issue, the judge has to weigh, am I willing to let a potential double first-degree murderer walk?
Well,
yeah, this judge, if they go through with this, and again, and what you're saying is exactly the reason why he wouldn't want a mistrial. So that's why I said, talk to him, make sure, does he want to sit in jail potentially for 2 more years without a verdict, or does he just want to go through with it?
And you may have what you think is a very favorable jury in this, here, and to put it off, you may not get as good of a jury next time. You might get a better one. You don't know, but now you're flipping a coin on putting your life in the hands of a set different 12 people.
Yeah, and that's if he agrees to the mistrial, and if they're allowed to refile or retry this case, it's going to be at least a year, possibly 2, before this comes back, which just means he's been there for 6 years. And do you want him to sit there for another 2 years and possibly be found not guilty, or do you just want him to try to be found not guilty now? It's just a matter, do you want to delay this by 2 more years?
Yeah.
And Jim also asked, why doesn't jeopardy attach to this? Why isn't it double jeopardy for the mistrial?
Well, maybe
mistrials generally are not covered by the double jeopardy.
Yeah, it's not being determined on the merits. This is an issue of law, and it's not a jury returning a verdict. This is not or a bench trial with a judge entering a verdict. This is not actual determination on the merits. Now, if he does it with prejudice, then double jeopardy would attach, because that essentially is, it's not on the merits, but you're barred from bringing it.
Well, and even I guess technically, even if the prosecutor or the judge causes the mistrial, double jeopardy still doesn't attach unless they acted in bad faith.
Yeah,
which is what MG's alleging that she did. He's
arguing. I just don't see how she didn't intend to do it when he specifically said, "Don't do this," and she turns around 5 or 10 minutes later and does it.
And the Oregon v. Kennedy is the case on this. The Supreme Court held that, quote, only where the governmental conduct in question, which would be the prosecutors bringing the statement, only where the governmental conduct in question is intended to goad the defendant into moving for a mistrial. So only her making that statement was trying to force the jury to request the mistrial. Into moving for a mistrial, a defendant raise the bar of double jeopardy to a second trial after having succeeded in aborting the first on his own motion. So I mean, it's a fine line. I mean, it could go either way. The court could say, yeah, you acted in bad faith, which is MG Law's argument, that you in bad faith. She knew she was not supposed to ask that question. The judge specifically said, "Do not ask that question," and she asked that question.
Yeah, he said, "Do not. You're not you are not testifying with your questions. Do not read these messages as part of your question." And she did it.
I mean, we're not arguing about whether it's
Yeah.
grounds for a mistrial.
Yeah.
And I think the judges would give it.
Honestly, it's hard to say, as a defendant, you're sitting there, you've already been in jail for 3 or 4 years, whether you're willing to risk being there another couple of years or not. But you this jury can't, I don't know how you can expect the jury or believe the jury is going to just forget the question that was asked.
Yeah.
And then you're hoping, at this point, you're just hoping that they forget by the end.
Yeah.
And
two quick super chats here. A nice Undertaker hat, Jeff. Sorry about your WrestleMania win streak, though. Yeah, it's kind of like I said, if you go back to the early days of the channel, you'll see it had a much different shape. And then I left it sitting too close to the edge of something, and Yoda treated it as a chew toy about 6 months ago, and just mangled the hell out of this hat. And which is why I ended up getting the Pale Rider black hat that I occasionally wear.
Which is that's an awesome hat too.
I couldn't bring myself to just throw this away, so I've been starching the ever loving hell out of it, getting it back in shape, kind of brushing out the dog teeth marks, and just making it nice and rigid again. So yeah, it's been. I still have to do something about the internal band that's been chewed to hell. But yeah, this is the reconstituted old cowboy hat that had a much different shape 6 months ago. All right, thank you for that, though. Thank you, Mandy. But yeah, it is sad about the Undertaker's WrestleMania streak. And Nick Naylor, this dude is 100% guilty, but this should be a mistrial with prejudice.
I can't say he's 100% guilty from what I've seen so far.
Yeah.
I mean, I don't know. I mean, there's still many more days left for the state's case, but
or Tuesday.
Yeah, it could be.
There's many more days or 0 days left. Yeah. So we'll find out on Tuesday.
And I think, the judge is going to go back, get with the court reporter, pull the transcript of these areas in question, review it, and see if he thinks she said what the defense says she said. Mm-hmm. And whether it can be implied that she meant the defense team taking care of the witness or not. But, he's going to take his time. They apparently got a long weekend, so he's got plenty of time to do it.
Yeah.
It goes like with Schroeder. I would have granted a mistrial with Zachariah Anderson with the way that Gravely acted. Judges I think are hesitant to do it, but and listen, the state can appeal. As a judge, you can't be afraid of being overturned on appeal. You can't care about that.
Yeah.
But I know a few judges that are like that. They're like, hey, you can appeal me. I don't care. Had that happen, and go ahead.
I was going to say, this is going to come down to Tuesday. Let's say, after consulting with your client, do you want to continue with your motion? Do you want to withdraw your motion, or do you want to continue with your motion for a mistrial?
Yeah.
And I think if they say we want to go with the mistrial,
I think
the judge is going to give it to him.
Yeah.
And then it's just a matter of whether it's with prejudice or not.
And that's I don't see a judge doing that, but I mean, I'm not sure how often that's happened.
With prejudice?
Yeah, I don't know.
Yeah. I mean, that's a pretty big decision for the judge.
Yeah, especially given it's a double murder case. But at some point, you have to have a proper sanction against either side for their actions. Yeah. And here, the state clearly overstepped the bounds they were told not to do, and in direct contempt of the court. And if he doesn't do it with prejudice, he needs to make it clear to the prosecutor, that I will be referring this to the bar. I've had judges do that. I mean, tell an attorney, hey, you've done this. I will be contacting the bar about this. So it's fun. When it's not you, it's fun.
Yeah. I bet the judge makes an admonition to the jury. You can't admonish this away.
Yeah.
I mean,
it's just, you can't. Yeah, you can. He told that he did admonish him. He said, forget what was said. That it's been stricken from the record. You are not to consider it. Well, that just tells them, okay, I need to. This is what did they say? Okay, that's what they said.
Yeah.
I'm supposed to forget this.
Yeah.
Yeah. Forget. Yeah.
Mamasaurus Rex. Do you think that this is what MG Law was just saying? Do you think the judge will watch the trial stream? No, he won't watch the trial stream. He'll
give it a
read the
court reporter.
transcripts. Yeah,
Yeah.
they'll get the court reporter over the weekend.
And
They'll
maybe he
clean it
will.
up and bring it in. Yeah.
I mean, maybe he will, just to be able to see it instead of just reading it, on paper, getting the full context of the
Yeah, he
room
could.
of how it was being. Because I don't see why he can't do that. I mean,
Yeah.
it's a televised proceeding.
yeah.
I mean, it's open
Yeah,
court.
there's no reason why he couldn't.
So,
But normally they would just read the transcript. But who knows? But yes, it can, and who knows? One way or the other, he's looking at the video trial, the footage. Do we use footage anymore, kids? At the trial footage, the transcript, or both, and then he'll decide what was going on.
yeah, I am curious what Schroeder did with the thumb drive of gravely mouthing, because he said, "I'm going to hold on to this."
Probably
And
nothing.
no, I mean, you should turn it over to the bar, but hopefully somebody has filed complaints against him there for that. But
Angel Australia says, seriously, due to the state's efforty, can the defendant make them pay his legal fees up to this point?
I mean, you could do it as a sanction, but I don't know that the judge. I mean, the biggest punishment he could do is mistrial with prejudice.
Yeah. Then your legal fees
Then
were
I guess.
worth it.
Then I guess I guess you could potentially bring a civil case.
Yeah.
Malicious prosecution, or which over here, I mean, they had good faith basis to charge him, so it's not really malicious prosecution. But
I mean, you would. I guess you could do it civilly, but probably wouldn't be successful, and B, I've never heard of anyone ever doing it.
yeah, I mean, you're not going to win it probably, but
Yeah.
I'd say the judge could issue it as a sanction. Of course, he would get appealed on that. But
Yeah, well, and David Delson says legal advice is bring it with you to Miller Hats. Maybe when I go, maybe they'll restore it for you. No, I like this new shape.
Yeah,
it's hell,
Sure.
I'm going there, and I'm gonna buy a couple other hats while I'm there. Certainly not going to drop the idea of a sponsorship. give me my plan is one hat every quarter for mentioning Miller Hats every time I wear it, which is basically every day. So. So that's my plan. If they say no, I'll go, all right, I guess I'll buy some more hats from you.
Yeah.
But I like that. I like this hat. It's got it now. Now I don't have to take care of it.
Yeah.
I mean, now it's just going to be my beater hat, which I mean, not for the summer because this is like beaver pelt and it's hot AF and it's black.
Yeah.
But it just keeps the shine off the dome here. Anyway, that's the end of our little program here today.
Yeah, it's fun. I'm up late. I got maybe 1 hour of sleep last night after that stream.
Yeah, I just fell asleep immediately. Woke up at 9:30, 10, and then thought, I should go out drinking with friends. That was the decision.
Yeah, it was 4 something here, and of course, trying to wind down from the stream. And I'm looking at my phone a little bit, and I in the dark, laying there, and I didn't want to disturb my wife, so I laid on the couch. And she came out like 20 minutes after I laid down, and she's like, "When'd you go to bed?" And I was like, "I don't know." And I was like, "No, I don't know." But then I was like, "Yeah, my sinuses are bothering me. I can't sleep," And then was up maybe an hour. I actually slept maybe an hour and a half. And then we went out, we went to Costco and did all kinds of stuff today. And she was like, and we were there when I dropped. Yeah, the stream ended at 4:00. She's like, what? Like, you're surprisingly good mood for not sleeping.
I've just got to be domestic. I got to be a good housewife today and then clean and do all the other stuff. The last question though here from Smopo Vienna, I think is a very good question. How is it possible that in the last 5 or 6 cases is so much state fuckery? Is there any statistic on defense v state on who did more BS? well, I don't know if you can quantify it in a statistic, but the reason it's possible in the last 5 or 6 cases is because it happens in a great deal of cases. You're just becoming aware of it because
Yeah.
streaming trials has become a popular thing. You're
Yeah.
seeing things that no one has ever seen before, by and large.
Yeah, they don't televise them here in Oklahoma. I did ask a judge after an eviction docket one time if he was, and he mentioned, as I mentioned, when I was watching some Judge Manning, he knows about Judge Manning and some of these other judges
Mhm.
streaming. I said, would you ever do it? He's like, no, this, with all these pro se, he said, so many people are pro se now. He said, I'm not comfortable doing it unless I got everyone's permission. And then the next time I was there a couple of weeks ago, we had a sovereign citizen come in, and he just lit this guy up. And it was great. He started, and I'm here on special appearance for on behalf of so and so, John Smith,
Yeah.
straw man,
All the trigger words. Yeah.
everything. And judge, he refused to cross the bar, come across the bar, and just like, okay, well, I'll just find that you're present, you refuse to participate, and I'm going to enter default, enter judgment against you.
Nice.
And he
Yeah.
starts laying in, and he starts, oh, this is improper. That's not lawful. And he's like, well, you can appeal. He said, you know where the Supreme Court is down here, downtown, down the hill here. He's like, you can walk on over there and appeal me if you want. I don't care. And then he called the deputies, and the guy took off. So
I like it when they do the, okay, well, he was summoned today. He didn't appear. You appeared on his behalf. You're in contempt. We're going to put you in jail, and if you see him, maybe he can pay your bail and help you out. I like those kind of things.
Well,
But,
we had legal aid attorneys there, and he joked with one of them. He's like, I was almost about to appoint you as counsel. He's like, if you'd have done that, he said, I would have jabbed my pen in my jugular before I represented him. He says this right in front of everybody.
Well, Smopo Vienna had a follow-up here. Said, true, I can't imagine what's going on with the common people. See, this is the thing. We just, all of our lives, we hear, oh, so-and-so was accused of murdering someone.
Mm-hmm.
Oh, the jury found him guilty. They did it. Well, yeah, okay, good for the, but then when you open these things up, you start to see what, it's like the old thing. You don't want to see how laws and sausages are made.
You're seeing what, obviously this evidence was presented. It's like, Murdoch. I mean, you have so many gaps in there, but these other things that were presented that, the financial stuff, even the juror said, oh, it just shows that he was, a manipulative. Well, that's character. That's not, him actually doing it. It's, oh, he's a bad guy. Which was why it should have never come in. It was obviously going to be character evidence, but.
Yeah. And the conclusion to the question is you see it more because you're seeing it more.
Mm-hmm.
You're seeing more trials, or you're seeing it more.
Yeah.
And that's really, it happens. And it sucks, but we're going to have to see how this thing plays out on Tuesday. Yeah. This is going to be interesting.
Yeah. And I'm in the office Tuesday, but I will be listening for sure.
Well, gosh, guess that kind of wraps everything up here.
Yeah.
I'm going to set us up now. If you like trials and all these other things and all this other fantastic stuff that goes on, Lincoln Kane may not be may not be your cup of tea. We're going to put everybody over into we're going to raid Lincoln Kane here. Let's see what's going on over. Okay, he's just talking by himself. If you're just into trials and you don't want to watch odd things, Lincoln Kane may not be your thing. But if you like F it Friday, like we did yesterday, then it's your cup of tea. Yeah, it's every day, all the day. It's just a thing. But I'm setting us up to dump into him. So if you don't want to be confused and bewildered and feel a little bit afraid, maybe you may want to exit now. And by the way, I'm so terrible. I haven't grifted me or you here. Hit the like button, hit the subscribe button. We're doing well. We're approaching. I think we're about 73 away from 37,300. What the hell? Not yet. 173 or something. I don't know. I can't do math. Never mind. We're continuing to grow. Okay, we're at 36,827. So we're 133 away from 37,000. 133 away from 37,000. That's awesome. I want to get there. I desperately want to get there. The like and subscribe buttons, I asked if you smashed them. 8% of you said objection, overruled. Yes. 20% of you said yes, I'm guilty of smashing them. 25% said yes, asked and answered, and 46% said I did under penalty of perjury. Okay, that's the end of our like and subscribe poll.
Yeah.
Thank you for participating in the daily lame thing. And again, I got to find something to do for Maritime Monday tomorrow, so think fast, Lorax. And then we'll jump back into the trial real time on Tuesday, and we'll run with it.
Yeah.
3 days next week. And while I'm setting this up, go ahead, MG Law, Grift. Who are you? What are you doing? Where can we find you?
I'm an Oklahoma lawyer. I'm at the MG Law on YouTube and Twitter and Locals, I think, as well. I haven't done anything on Locals at all, I don't believe, but I have 177 subscribers, and I haven't really put out anything in a while. Been kind of busy and surprising, actually up really late tonight, but usually by the time I get the kids to bed, I'm exhausted from the day and I just go to bed. So, but I'm going to try to find some things to post here soon, but I'm usually in chat.
Well, go and subscribe to it.
Yeah. It doesn't cost
Criminally.
anything to like and subscribe. So
Criminally undersubscribed. So get the subscriptions up. Give his videos a watch. And now's the moment of truth, people. Thank you, mods, for being here. Thank you all. Deeply appreciate you. Deeply appreciate the chat. The Vice Racks, the Vice Squad, the Legal Vices chat is the best chat on YouTube. That's all there is to it. No question. Join me Tuesday for the resumption, hopefully, maybe, possibly, of this trial. Or otherwise, let's watch the mistrial as the prosecution goes down in flames. And join me tomorrow for some form of Maritime Monday. Thank you for being here. And we're going to send you over to Lincoln Kane now. If you got the courage, go on over. Tell them it's a Vices raid. Good luck with that. I love Lincoln. Well, I'll pop on in a bit here. Got to start another load of laundry. Until then, take care.
Yeah, and it's Monday for everybody here in the States for Maritime Monday. It's going to be tomorrow for you, but it's Sunday. It's not even Sunday here. It's still Saturday.
Oh, yeah. Yeah, it's Sunday morning here, so Monday. Monday is my tomorrow. On Monday, Maritime, it's like right there in the title. Maritime Monday.
Yes.
Tomorrow for me, 2 days from now for some of you. Yeah. All right. Cheers, people. Take care. Go to MG Law. Go to me, and let's go see what's happening over at Lincoln Kane. Let him know Vice Racks, Law Racks, Legal Vices sent you. Bye now.